Good evening. If you could please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Good evening, everyone. I want to welcome you to the October 19th, 2020 Zoning Hearing Master Hearing. My name is Susan Finch, and I'll be presiding as the hearing officer over tonight's agenda. Let me start by introducing Mr. Brian Grady of the Development Services Department, who will go over our changes for tonight's agenda.
Good evening, Ms. Finch. Again, for the record, Brian Grady, Hillsborough County Development Services. We have two changes to the published agenda. The first change is on page 6 of the agenda. Item D3 is rezoning application PD 20-0330. Staff is requesting this item be continued to the November 16, 2020 zoning hearing master hearing. Madam Hearing Officer, the reason for the continuances request is that there's a design exception that needs to be reviewed as part of the zoning application that has not been placed in the record and reviewed yet. And per board direction, all of the design exceptions for roadway improvements have to be included in the record as part of the zoning, and therefore, because of the lack of that information being in the record and being reviewed, this needs to be continued in order to give time for that to be reviewed and included in the record.
Okay. Let me just ask if there's anyone here that wants to address the continuance of agenda item D3, which is rezoning PD 20-0330. Anyone here to address that item regarding the continuance only?
Yes, this is Matthew Campo. Can you hear me?
Excuse me? Someone?
This is Matthew Campo. I'm virtual.
Okay. Good evening, Mr. Campo.
I'm representing the applicant on this. I'm just available for any questions. What Mr. Grady mentioned was correct. It's what we consider to be a minor item, but obviously it needs to be completed. So the extra time would allow us to.
Mr. 392, not 330. So that's the next one on the change.
Oh.
Mr. Campo, we'll be dealing with the next item next.
What are the odds of that? 2 in a row.
The one before that, D3. So we'll be with yours shortly.
All right.
All
So
right.
is the applicant here for rezoning PD 20-0330, item D3? Yes, sir. You just want to put your name on the record, or is that necessary, Brian?
No.
Yeah, because it's a design exception issue. Okay. All right. Then seeing no one here that would like to speak to the continuance other than the applicant, we'll continue item rezoning PD 20-0330 to the November 16th, 2020 zoning hearing master hearing at 6 p.m.
The next change in the agenda is also on page 6, item D4. This is rezoning application PD 20-0392. The applicant is Paresh Joshi. The staff is requesting this item be continued to the November 16, 2020 zoning hearing master hearing. Madam Hearing Officer, similar to the last case, there is a design exception for this that needs to be revised in order, and again, that did not occur yet, and therefore, in order to incorporate that revised design exception into the record, this item does need to be continued. And again, this is the case that Mr. Campo wanted to speak about as the applicant representative.
All right. Well, Mr. Campo, did you have anything? I know you're participating virtually. Is there anything you wanted to add to that?
Nope, just available for any questions.
All right. None at this time. Is there anyone here in the audience that would like to speak to the continuance of agenda item D4, rezoning PD 20-0392? All right. Seeing no one, then we will continue rezoning PD 20-0392 to the November 16th, 2020 zoning hearing master hearing at 6 p.m.
I will now go through the published withdrawals and continuances beginning on page 4 of the agenda. The first item is item A1, major mod application 19-0521. This application out of order to be heard has been continued to the November 16, 2020 zoning hearing master hearing. Item A2, rezoning PD 19-01344. This application is continued by the applicant to the November 16, 2020 zoning hearing master hearing. Item A3, rezoning PD 20-0103. This application has been continued by staff to the November 16, 2020 zoning hearing master hearing. Item A4, rezoning PD 20-0154. This application has been continued by the applicant to the November 16, 2020 zoning hearing master hearing. Item A5, rezoning PD 20-0286. This application has been continued by the applicant to the November 16, 2020 zoning hearing master hearing. Item A6, rezoning standard 20-0312. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. Item A7, rezoning standard 20-0334. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. Item A8, rezoning standard 20-0358. This application is being withdrawn from the zoning hearing master process. Item A9, rezoning standard 20-0374. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. Item A10, rezoning PD 20-0382. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. Item A11, rezoning PD 20-0389. This application is being continued by the applicant to the November 16, 2020 zoning hearing master hearing. Item A12, rezoning PD 20-0394. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. Item A13, RZ-PD 20-0690. This application has been continued by staff to the November 16, 2020 zoning hearing master hearing. Item A14, Major Mod 20-0898. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. Item A15, rezoning PD 20-0985. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. Item A16, Major Mod 20-1068. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. Item A17, Major Mod 20-1070. This application out of order to be heard and has been continued to November 16, 2020 zoning hearing master hearing. Item A18, RZ-PD 20-1071. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. Item A19, rezoning standard 20-1078. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. Item A20, rezoning standard 20-1170. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. And item A21, rezoning standard 20-1171. This application is out of order to be heard and has been continued to the November 16, 2020 zoning hearing master hearing. That concludes all withdrawals and continuances.
All right, thank you very much, Mr. Grady. I appreciate it. Let me start by going over our procedures for this evening's hearing. Tonight's agenda consists of agenda items that require a public hearing to be held before a zoning hearing master prior to the final decision, which is made by the Hillsborough County Board of County Commissioners. I'll conduct the hearing tonight as the hearing master and will make a recommendation on each application 15 business days following tonight's meeting. The recommendations are then sent to the Board of County Commissioners, who make the final decision at their public meeting. Our hearing process tonight will be informal. I'll ask questions related to the direct testimony presented tonight. I'll call and question witnesses as I deem appropriate and necessary, and will decide all questions of procedure. Irrelevant, immaterial, or unduly repetitious evidence will be excluded. Any part of the evidence may be received in written form, and all testimony must be under oath. Hearsay evidence may be used for the purpose of supplementing or explaining other evidence, but shall not be sufficient in and of itself to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation tonight is as follows. Mr. Grady of the Development Services Department will provide a brief introduction of each agenda item. We'll then turn to the applicant, who has a total presentation time of 15 minutes. Next, we'll go to the County Development Services staff planner that was assigned the case. They will have 5 minutes to present the county's staff report. Next, we'll go to the Planning Commission, who will also have 5 minutes to discuss the application's consistency with the comprehensive plan. Then we'll turn to proponents, anyone that would like to speak in favor of an application. Everyone, total proponent presentation time is 15 minutes. The same is then true when we turn to opponents, anybody who would like to speak against an application, 15 minutes altogether. Then back to county staff, if they will have 5 minutes to address any item that was brought up, recommendation or condition. And then finally, we go back to the applicant, who has 5 minutes for rebuttal. If you are going to speak tonight, we suggest that when you come up to the podium to speak, or if you are participating virtually, that you always start by giving us your name and address for the record. We are recording this hearing and we want to make sure we have your name accurate as to the petition that you're speaking to. When you're done speaking, if you're here with us physically in the building, if you could see Elise to my right, she's with the clerk's office, and she has a written sign-up sheet where you will also sign in your name and address and the application number that you were speaking to. Let me now go to Mr. Clark of the County Attorney's Office. who will explain the legal requirements for oral argument that will govern your participation if you would like to speak at the Board of County Commissioners meeting. Mr. Clark.
Thank you, Ms. Finch. Good evening. My name is Cameron Clark. I'm an assistant county attorney. Tonight's public hearing is the first step of a two-step rezoning process. This hearing is the time for rezoning applicants and interested parties to present testimony and evidence. Any evidence presented tonight will become the complete factual record of each application, and no additional evidence can be introduced after the closing of each application. The second step of the rezoning process is a public meeting before the Board of County Commissioners, where the board will take a decision on each application heard tonight. Tonight's applications are scheduled to be heard by the board at its December 8th, 2020 land use meeting. When considering applications, the board will only consider the record created at tonight's hearing and the recommendation made by the hearing master for each application. The hearing master will file a recommendation for each application heard tonight on November 9th. Any party of record wishing to address the board at its public meeting must execute and submit a request for oral argument form explaining why oral argument is necessary. Requests for oral argument must be responsive to the hearing master's recommendation. Therefore, such requests cannot be filed until after the hearing master has submitted her recommendation to the county on November 9th. Following this date, any party wishing to address the board at its public meeting will have 10 days to submit a request for oral argument to the clerk of the Board of County Commissioners. Therefore, for tonight's applications, if you wish to address the board at its December 8th land use meeting, you must file your request for oral argument between November 9th and the close of business on November 19th. While the board is not required to hear oral argument at its public meeting, the board can elect to hear oral argument from a party of record. A party of record is someone who fits into at least one of the following four categories. First, someone who is present tonight and presents testimony or documentary evidence. Second, someone who is certified by the U.S. Postal Service as having been mailed notice of tonight's hearing. Third, someone who submitted documentary evidence to the master file at least 2 business days prior to tonight's hearing. Or fourth, someone who submitted documentary evidence by proxy at tonight's hearing. Should the board elect to hear oral argument, parties of record will be eligible to address the board if their requests for oral argument are responsive to the hearing master recommendation, and if they clearly set forth why oral argument is necessary to address at least one of the 4 outstanding issues that are laid out in section 10.03.04E of the Land Development Code. If the board elects to hear oral argument, the content of the argument shall be limited to the content of the testimony and other evidence that is submitted verbally or in writing to the hearing master tonight. It is the role of the county attorney's office to ensure that only individuals who have met these requirements are allowed to speak before the board, and to ensure that no new evidence or testimony is introduced or allowed at the board's public meeting. For these reasons, please make sure that all information you wish the board to consider at its public meeting is entered in tonight's record. Thank you.
As I mentioned, all testimony must be under oath. So if you plan to speak tonight, if you could please stand if you're in the building, and also if you are participating virtually, if you could please stand and raise your right hand and also raise your hand. You solemnly swear to tell the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Thank you. Please be seated. All right, Mr. Grady, we're ready to call the first case.
The first item is agenda item C1, is rezoning standard 20-0144. The applicants are Maria Carmen and Lutz Lopez. The request is rezoned from agricultural single family 1 to business professional office with restrictions. Tanya Chappella will provide staff recommendation after presentation by the applicant.
All right, is the applicant here? Not virtual, right? Is the applicant here for the first agenda item, C1, rezoning standard 20-0144?
Madam Hearing Officer, we'll see if we can contact the applicant and find out their status, and we'll move on to the next item then.
Okay, perfect.
The next item is agenda item C2, rezoning standard 20-1047. The applicant's TSP Companies Incorporated. The request is rezoned from RDC 12 to commercial neighborhood. Tanya Chappella will provide staff recommendation after presentation by the applicant.
Understand the applicant is virtual.
Good evening, Ms. Finch. For the record, I am David Wright, president of TSP Companies. Our address is PO Box 1016, Tampa, Florida 33601. This is a request to rezone a 0.59 acre property from RDC 12 to CN, neighborhood commercial. This is a pretty straightforward request, and the Development Services and Planning Commission staff reports adequately describe the application and found it to be approvable and consistent with the comprehensive plan. There are a couple corrections I'd like to point out that need to be made to the Development Service staff report. First of all, section 1.3 states that the property is not within the urban service area. It is within the urban service area. And then under section 1.5 compatibility, I think the second paragraph needs to be struck. It seems to relate to a different piece of property located on South Highway 41, and it talks about CI zoning. This request is for CN. I'm not aware of any opposition to the request, and based on the documentation within the public record and my testimony here tonight, I respectfully request your recommendation of approval, and I'm available to answer any questions.
Okay, correction, you mentioned in the staff report, what paragraph are you in? CI.
Under 1.5 compatibility, it would be the second paragraph of that section. The subject property is located in South Highway 41.
So it says, I don't see a reference to CI. Where are you looking for that?
My staff report that I'm reading has a second paragraph that says, and on the second line, containing several properties zoned CI with light industrial uses.
Oh, maybe that was corrected by the
Okay.
in time for the version they gave to me, because yeah, mine doesn't read that. It reads the subject property is located in a commercial corridor containing several properties zoned CN, CG, and PD approved for commercial uses such as car wash, retail, gas stations with a convenience store. And then it has the table with the surrounding uses.
Great, then that is correct. So thank you.
You're right, you cut out for just a minute. Could you repeat your last statement?
I said what you just read is correct. So thank you for pointing that out to me.
Perfect. The clarification. All right, and I didn't have any further questions. We'll turn to Development Services.
Good evening, Tanya Chapella. I will forward the report to the applicant. The request is to rezone approximately 0.59 acres from RDC 12 residential duplex conventional to CN commercial neighborhood. The subject site is located in the Sefner Mango community south of MLK Jr. Boulevard East, about 500 feet southwest of the intersection of MLK Jr. Boulevard East and Lemon Avenue County Road 579. The subject property is located in a commercial corridor containing several properties zoned CN, CG, and PD, approved for commercial uses such as a car wash, retail, and gas stations with convenience store. The adjacent properties are zoned CM, BPO, RDC 12, and SC6. Staff finds that the proposed zoning district CN is compatible with the surrounding development and zoning patterns. No objections were received from the reviewing agencies. So staff finds that the proposed request is approvable. This concludes my presentation. Thank you.
All right, thank you very much. Planning Commission.
Jawan Haley, Planning Commission. The subject property is designated Residential 9 on the future land use map. It is located within the limits of the Sefner Mango Community Plan. The site is located within the urban service area. The proposed rezoning to commercial neighborhood would allow for uses that are compatible with the surrounding development pattern. These uses are permissible within the Residential 9 future land use category, subject to applicable comprehensive plan goals, objectives, and policies per policy 22.2. Locational criteria is a plan objective that directs commercial development at the nodes of qualifying intersections and is required for projects within the Residential 9 future land use category. This site meets commercial locational criteria. Policy 16.1 and 16.3 requires new development to be compatible with surrounding uses. Policy 16.5 requires development of higher intensity non-residential land uses that are adjacent to established neighborhoods to be restricted to collectors and arterials in 2 locations external to established and developing neighborhoods. The proposed rezoning is located on Martin Luther King Jr. Boulevard and Arterial. The proposed rezoning satisfies the intent of policy 16.1, 16.3, and 16.5. The subject property is within 1,000 feet of the Martin Luther King Jr. Boulevard and Mingo Road intersection. The intersection has 2 convenience stores with gas, while the northeast corner includes a bank and a community-scale shopping center, which includes a big box retail use. The requested change in zoning is comparable to uses already existing at this intersection. The proposed rezoning furthers the goals of the Seffner Mango Community Plan, seeking to enhance community character and ensure quality residential and non-residential development by supporting infill development and redevelopment within the urban service area while providing for compatibility with existing uses. Based on these considerations, Planning Commission staff finds the proposed rezoning consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Very much, I appreciate it. All right, is there anyone here that would like to speak in support of this application? Anyone in support? Seeing no one, anyone in opposition to this application? No one? Mr. Grady, anything further?
Nothing further.
All right, then with that, we will close. Oh, I'm sorry, Mr. Wright, did you have anything you wanted to add before I close the hearing?
No, thank you.
All right, thank you for that. Then we'll close rezoning 20-1047 and go back to the first case if we have some information.
It's our understanding that the applicant was planning on being here, but they're not here yet, so we haven't been able to get in touch with them, so I would move on. We'll
All
just
right,
continue
then we'll move on.
with the agenda and hopefully they'll arrive soon.
Perfect.
The next item then would be agenda item D1, rezoning PD 20-0307. The applicant's RKM Development. The request is to rezone from AS1 to planned development. Michelle Heinrich will provide staff recommendation after presentation by the applicant. I did hand out some revisions to condition 3, which clarifies the intent of the condition requiring a cross-axis stub out, some additional language to further clarify the intent of that condition. That's been placed in the record, and staff can speak to that if you have any questions. And again, Michelle Heinrich will provide staff recommendation after presentation by the applicant. Thank you.
All right, good evening.
Good evening, Cami Corbett for the record with the law firm of Pillward and Henderson, 101 East Kennedy Boulevard, Suite 3700. In the interest of time, what I'm going to do is I'm going to go ahead and have Mr. Horner, who's our planner, come up and present his testimony regarding planning issues. And then we'll have Mr. Yates, who is our transportation expert, come up and provide some information. And then I'll do some cleanup at the end. But we are in agreement with the revised conditions. I'll just say that.
All right, thank you.
Good evening, Ms.
Good evening.
Finch. For the record, I'm Michael Horner, 14502 North Dale Mabry Highway, Suite 200. Tampa, Florida, 33618, representing RKM. And I have been sworn. Just a brief commentary. I'm representing RKM Development, by the way. Brief qualification comment. I have a Bachelor of Science degree in Urban Regional Planning. Been in this profession for over 40 years. I was former county planner for Development Services, also former county planner of the Planning Commission, and former chairman of the Land Use Appeals Board for 10 years. I'll file my CV into the record after my presentation. Ms. Finch has been a long time on this case. Madam Clerk, if I could just have 5 minutes, please let me know. Great, thank you. Just so I don't over. All right, thank you. 5 minutes, give me a buzz, and I'll turn over to Mr. Yates. We've been a long time in this process. I think our pre-application was back in October of 19. We then had a instatement of a moratorium by the Board of County Commissioners. That moratorium, the RP2 area, was lifted in December, and we filed the very next day to this PD rezoning. So we've been in this process for almost a year. We appreciate working with staff, transportation, as well as Development Services and Planning Commission. This is a 1.14 acre tract. This is an intersection of Big Bend Road, Baum Riverview, and Gordon Road. So we have three right-of-ways at this intersection. Both Baum, Riverview, and Big Bend are collector designated roadways, Ms. Finch. Gordon, of course, is a local street. This intersection has recently had intersection improvements. I'm going to have Mr. Yates discuss that, but if you go out and do your field check, you'll see those improvements are in place with extended medians, and that is why we're seeking the access to Gordon Road. This is zoned AS1. We are in the RP2 plan sector. We are asking for the PD zoning district. Public water and public sewer are available. Utility lines are in the right-of-way. I would note that since we are in RP2, which technically is in the rural service area, on my narrative, Ms. Finch, we did file for a waiver to allow use of public utilities. I didn't see staff reference that in the report, but I think the Planning Commission acknowledges this on page 2 of the report that indicates expansion of those systems should be prohibited. We are not expanding or extending public water and sewer. They are in place, and I will also file the water resource review and public sewer review that indicates no objection. So for the record, I want to just make that clear. Ms. Finch, this case meets all locational criteria provisions. We are asking for no waivers. We have no PD design variations. We meet all buffer screening requirements of 60606. We have one residential lot to the north, which requires a type B 20-foot buffer. And we provide that along our entire northern boundary, plus 6-foot 100% opaque PVC screening and landscaping. That lot, we think is a quasi-commercial lot, quite honestly. It's got a lot of truck parking and storage parking. It is zoned AS1, but we have not had any objections or opposition from anyone for that matter. But I do believe that house is used for a number of operations that are not entirely single-family detached. We're asking for a 3,450 square foot convenience store with a gas pump canopy, plus a car wash. Car wash is located parallel to Gordon Road. We've filed numerous iterations, Ms. Finch, with staff. I want to think at least 7 to 8 plans. We're pleased to stand before you with Development Services recommending approval. Unfortunately, Planning Commission, because local street access has found us inconsistent, I'll address that comment in a moment. We have the Summerfield Elementary School to the west. And we have a large church to the south. We have a planned unit development to the southwest with all internal oriented lots. And then to the east on Gordon Road, we have single-family homes, but those lots are directly facing away. They have no access to Gordon Road. Their access is to Big Bend. No conflict with our turning maneuvers. This is the long-range plan, the comp plan designation. You can see, Madam Hearing Master, we are truly on the edge, not just one community, but 2 communities. We meet all those criteria for non-residential uses. Again, we meet locational criteria, no waivers are necessary. We have gone through a number of plan discussions with staff. We have agreed to a number of conditions that we think protect all parties. Again, we have no design variations. This development, if you look at the aggregated parcel planned village policy, and I'm going to provide a copy of this to you, Ms. Finch. That policy actually states they are allowed to consider non-residential neighborhood serving uses, not to have any locational criteria adherence. We, of course, meet all locational criteria. And the purpose of that policy on page 66 under policy 33.3 is to ensure that the neighborhood commercial needs of the aggregated planned village are met. So any parcels less than 50 acres may be considered for neighborhood commercial uses without even meeting locational criteria. That's the plan policy. We, of course, are right at 3 intersecting right-of-ways, and we do not have any waivers for locational criteria since we're at that corner. Is that 5 minutes? All right, 30 seconds. The other policy I want to address briefly is policy 16.5. That is one of the objections of the Planning Commission. Madam Hearing Master, that policy states development of higher intensity non-residential uses that are adjacent to established neighborhoods shall be restricted to collectors and arterials and to locations external to established and developing neighborhoods. I would note for the record that that policy does not preclude access. It simply says if you're going to have a non-residential use, neighborhood serving, it shall have access to a collector road, and we do. In fact, we have access to 2 collector roads. So that policy is not dispositive of not compliant. I would offer my opinion that we clearly do not undermine that policy, and we are consistent with policy 16.5. I'm going to file the rest of the documents into the record for your review. Happy to answer any questions. Thank you.
I just have a quick question,
Yes, ma'am.
and maybe that is in your transportation presentation and with Mr. Yates, and that's fine. But the staff report, the county staff report talks about 2 access points being needed for this project. Was there ever a consideration to not have access to Gordon?
I'm going to defer to Mr. Yates since he's done all the transportation.
Okay,
Guidance on this. Thank you.
fair enough. Thank you. Good evening.
Good evening, Michael Yates, Palm Traffic, and I have been sworn. Yeah, and I can answer your question. It's part of my presentation. There we go. Make sure I
Just a little lower.
There
There
we
you
go.
go.
Sorry about that. So this is for a gas convenience, 3454 square feet, 12 fueling positions. The fueling positions are located along Balm Riverview Road. What we are proposing are 3 access points, a right-in, right-out to Balm Riverview, a right-in, right-out to Big Bend, and then a full access to Gordon Road. The county as recently did a transportation improvement at this intersection. It was a developer-funded improvement that added a southbound left turn lane here on Balm Riverview onto Big Bend. They signalized the intersection, and then they added a westbound left turn lane on Big Bend to go south on Balm Riverview. So what that did is that basically made this a right in, right out, and made this a right in, right out without the ability to make a left in. So if you're coming into the site from the north, these are all 2-lane undivided roadways. So the only way to get in from the north is to make this left here, and to come in Gordon Road. So we tried to find a way to do it, but because of being a corner parcel and with the limited frontage on Balm Riverview and the location of Gordon Road to the back, this was the only way to get people into the site from the north. And because it's a 2-lane undivided roadway, you can't make a U-turn on the road safely anywhere. And so that is why we needed access to Gordon Road. And then likewise in the exiting movement to go east on Big Bend Road, the only way to go east is to come out here and then make the left here. Otherwise, you would have to make a right out, and there's nowhere to make a U-turn on Balm Riverview because it's 2-lane undivided roadways.
So it's your testimony that if you're, the only way to get into this site, if you can have the graphic back up.
Yep,
If you're going south on Balm Riverview
correct,
and you make that east turn,
correct.
or if you're going east on Big Bend, in those 2 scenarios, the only way to get into this site is to go north on Gordon and turn in.
Yeah, so if you're coming in on Balm Riverview southbound.
That's what I mean, south on, and then you
And
turn
then
east.
exiting, the only way to go east on Big Bend is to come out Gordon Road.
All right, and
Make
is it,
that,
oh, I'm sorry, go ahead.
yeah, make that right and then make the left here. So what we were doing is providing the left turn lane on Big Bend to get the traffic out of the through lane. And so to give a left turn lane that is not there today. So that is one of the improvements that we've agreed to do, is to basically widen this section of Big Bend to provide a left turn lane for Gordon.
Okay, and is it still the condition that if the parcel to the north develops commercially or with office, that Balm Riverview right in, right out would close?
Yeah, so what we've agreed to with staff is that if this parcel to the north develops as commercial or office, this access would close and be relocated up here for this parcel. And then this would be the shared access. You see it shaded here. And because this is a gas convenience and we have fuel trucks and this is the fuel truck route, we've tried giving a larger area for where that cross access could be, because we don't know what this could be and what the parking lot would lay out, or the building layout would be. So we wanted to give as much flexibility as we could, because they would need to accommodate a tanker truck to come in, make this right turn lane, and then come back into the site. I'm going to show you some similar sites, and as part of that similar sites, I will point out one that's very similar to this. That is a good example that will show you what that would look like.
Okay.
But we've agreed to build a right turn lane. So it will be a pretty short right turn lane here now on Balm Riverview Road. And then when this, if this closes and this moves up, it will become a longer turn lane and serve that. We've done 3 administrative variances with this project. One is for number of access points, which is obviously because of the limited access to each of these roads is why they're needed for each of them. The second 2 are spacing from the intersection for Balm Riverview and for Big Bend Road. And the county engineer has found those acceptable and approvable pending approving of the zoning. The other part to this is that we've agreed to improve Gordon Road to TS3 county standards. So we're not asking for a design exception for Gordon Road. So we will improve it from where it connects to Big Bend Road to the northern radius of this driveway. So any car that's coming into this Gordon Road would be accessing a standard roadway and designed to county standards. Let me walk through a couple of the similar sites so you can get a feel for. There we go. So this is 78th and Camden Field Parkway. So 78th Camden Field Parkway. This is a 7-Eleven. And so this is under construction, but I will submit into the record some site photos so you can see current photos that have been constructed out there. It's complete. But basically, this is an existing neighborhood here, Canterbury Lakes. And the driveway actually connects into the back of Canterbury Lakes and has a full access to the 7-Eleven. So this is a single family home and this is a single family home. So you can see the adjacent single family lots. This is under construction, just got completed very recently. All right, so the next one is a Circle K. This is Gibsonton Drive. This is Old Gibsonton Road. And this is Privat Street. Gibsonton is an arterial. Old Gibsonton is a collector, is a local road, as well as Privat. You can see the driveway connection to the local road. You actually have single family houses fronting on it with actual driveways in the vicinity of the driveway.
Is that one channeled to Privat? Is that channeled to?
This was channeled for inbound only.
Yeah.
On Privat, and then Old Gibsonton, which is also a local road, it's a full connection. Trying to get my directions. So this is a mobile gas station here. And then this is Gibsonton. This is on the east side of 75 from where the other one was. This is Fern Hill. And this is Brandwood Drive here. Fern Hill is a local road, as well as Brandwood. And so you can see, again, single family home with the driveway connection right opposite. And there is a single-family home right here on Fern Hill as well. But both of these are local roads.
Do you know, and maybe this is more Mr. Horner's question, but do you know if the scenarios you've presented are all part of planned developments where there was a commercial portion planned as a part of the overall project?
I do not, but as part of my package that I will give you, will have the folio numbers to them.
Okay.
But yeah, I do not know, but I know this was a standalone parcel that was recently completed.
All right, thank you.
I'll get through the last few real quick. This is another one. This is a Wawa at Boyette and Bell Shoals, Boyette, Bell Shoals. And then it also has a connection here to Deep Brook, which is a local road. But you can see the connection here. Again, single-family houses fronting right opposite the driveway. This has existing access to Boyette and Bell Shoals and interconnection again to Bell Shoals, but it still has access to the local road. I got two more to go through real quick. Again, this is the racetrack, Minnesota local road. This is 301 Riverview Drive. A connection to a local road. There's this existing single-family house back here. This is the one that was important that I wanted to share with you. This is US 301 in Sims. And so obviously 301's in Ontario. Sims is a collector roadway. Sims Lake is a local road. So this is the 7-Eleven on the corner. It has a auto parts store just to the north parcel. So this would be very similar to what we're talking about if a auto parts store went on the parcel to our north. But you can see the driveway that serves this gas convenience is moved to the north. And so you could come in this driveway and then get into the gas convenience store. And then it has the access out the back to Sims Lake, which serves in an existing neighborhood. But this, to me, is a very similar example to what we're proposing, what would happen when that access that is shown here today relocates to the north.
Okay.
That's it for time, and I'll submit all these into the record for you.
All right, thank you so much.
Ms. Finch, again, Michael Horner for the record. Just briefly, those cases, they're all zoned PD. A couple are part of a master plan. Most are PD zoned separately. And we've attached those documents for you in the record.
Thank you.
I just want to address the buffering and screening. We are actually enhancing, Ms. Finch, on Gordon Road. Disoriented, correct?
Yes.
Enhancing Gordon Road, landscaping here, and a 10-foot setback from 8-foot, which is your standard. And then again, a 20-foot full buffer. We're allowed to cross through here without a design variation because it's transportation required access condition for the cross access. Another case I want to give to you tonight, I just pulled it back from the clerk, is petition 18575, which is a PD, which was approved at Rodine Road in Balm Riverview. That is right to the north of this site, further north. You can see, Ms. Finch, we have single family directly abutting this site. Staff's recommended approval. Planning Commission found it consistent and no objections that I'm aware of, and the board approved it. That was AS1, RP2, rural service area, and same exact use as we proposed. On the 16.5 policy, I would just note again that if that policy is now to be interpreted that no access to local streets, as Mr. Yates just showed you, that would eliminate, I would say, 75% of all those small single lot parcels PD for neighborhood residential serving commercial developments, because almost all of them have to have some degree of local street access. Thank you very much.
Thank you. Appreciate it. Ms. Corbett?
Very briefly, I think that the substantial competent evidence that you heard this evening supports that this application is consistent with both the Land Development Code and the Comprehensive Plan, and we respectfully request your approval.
Thank you very much. I appreciate it. We'll now turn to Development Services.
Hi, this is Michelle Heinrich, Development Services. As you heard, this is PD 20-0307. It's a 1.14 acre site currently zoned AS1, and this is a PD rezoning to allow for a convenience store with gas sales and a car wash. The total square footage will be 4,434 square feet, which results in an FAR of 0.08. As you heard in the application, this is located in the RP2 future land use category area, which potentially allows a maximum FAR of 0.25. It is also located in the Riverview Community Plan area. That area is not subject to the current moratorium that is applied for many of the RP2 zonings. As you saw in the maps provided by the applicant's team, it is located in the northeast corner of Big Bend Road and Baum Riverview Road with Gordon. Of the proposed uses.
Michelle, we lost you there for a second. Could you repeat the last few seconds?
Sure. How's that for you, Christian?
We can hear you now where you're cutting in and out. Could you reread the second half?
Sure. I just reconnected to the VPN network for us. That should help.
Yes, go ahead.
Okay. As I was just stating earlier, is what you did see from the applicant's maps was that the property is located at the northeast corner of Big Bend Road and Baum Riverview Road, with Gordon Road located along the east. In our review for compatibility and appropriateness of the proposed use, we found the following. Firstly, the area to the north is zone AS1. It does have residential development oriented towards Gordon Road. The closest lot is 0.66 acres in size, and it is developed with a residence and several accessory structures. LDC required buffering and screening will be provided along this common boundary, and the closest building on the project site will be located 45 feet from that property line. And also the buildings for this project are limited to a maximum height of 25 feet, 1 story. If the 2-for-1 setback was to be required in this case, it would exceed that requirement. Next, the area to the east is also zoned AS1. It's separated from the site by Gordon Road, and that's a right-of-way width of approximately 80 feet. Buffering and screening along this boundary is not required. However, as you heard Mr. Horner state, they are providing buffering and screening in the area north of that access point. The closest property is over 1 acre in size. It's also developed with a single family home, and that is oriented towards Big Bend Road. The convenience store will provide a 54-foot setback, and the car wash will provide a 28-foot setback, and that's from the property line. Again, the heights are limited to 25 feet, 1 story. While an access point is provided along Gordon Road, the applicant has agreed to prohibit any fueling trucks from using this access. Otherwise, this full access will provide accessibility to and from the surrounding residential without the need to travel on Big Bend or Baum Riverview roads. Property to the west is developed with an elementary school and is separated by Baum Riverview Road. And lastly, to the south is a church, and between the site and the church is Big Bend Road, which is approximately 97 feet of right-of-way. As you heard the applicant state, there are no PD variations that are requested, and the proposed intensity is significantly less than what is potentially permitted in RP2. No reviewing agencies provided any objections, and staff does recommend approval. And transportation staff is also available to speak, as they would like to provide some updated conditions and findings. Thank you.
Before we go to Mr. Ratliff, I have a couple of questions. First, can you tell me, the staff report mentions that this property is located in the residential district of the Riverview Community Plan. Can you tell me what that means and what uses are permitted in that?
I believe, and that is located in the comprehensive plan. I don't believe that the comprehensive plan, that is kind of a conceptual map, provided much specifics into what's permitted, but the RP2 future land use does promote or does allow both residential and non-residential uses.
That back to the Planning Commission. Second, what can you go over again? What is located at the other points of the intersection of Balm Riverview and Big Bend?
You mean to the west and to the south?
Yes, ma'am.
Okay, to the west is an elementary school, and to the south is a church.
It's the closest existing commercial development in
the closest, the closest non-residential would be the elementary school. I don't know from my analysis what the closest commercial would be.
And then lastly, the condition that talks about the Balm Riverview right in, right out being temporary access or closed if their property to the north develops as commercial or office. What is that property zoned right now, that property to the north?
AS1.
Okay. And so do you believe that if this is approved, this rezoning is approved, that that gives a basis of precedent for the application to the north to come in if it were to apply for a rezoning for a office or commercial use?
I don't believe it would set a precedent. It would certainly be reviewed on a site-specific process. We do not know if that property were to come into the north to be rezoned, what exactly it would be used for, and if it would meet locational criteria.
All right, those are my only questions. Thank you so much. All right, Mr. Ratliff, good evening.
Good evening. For the record, James Ratliff with the Transportation Review Section. I did want to just go over a few things with you. So Brian, I believe, handed in the revised change, which I believe we heard from the applicant that they are supportive of. Essentially what that—
And I did get a copy of that. What was the change?
Essentially what it is a change to condition 3, where it says that it is the intent of this condition that the access/cross-access area be designed to accommodate fueling and other vehicle types. It simply adds to the end of that sentence, necessary to operate the proposed convenience store with associated fueling pumps and car wash.
Okay, thank you.
So just provides a little bit additional clarification. We did have quite a few conversations back and forth between staff and the applicant. I want to just put on the record that, that condition it's not intended and cannot, as you know, Madam Hearing Officer, place conditions on an adjacent property. So this condition obviously sets forth the intent for that access and the design on this property. We certainly believe that if that property comes in and develops per the conditions set forth in the zoning, that that it is possible to have a compatible access which does serve the needs of the gas station and would allow that access on Riverview Road to be approved in a more compliant location instead of the current location, which is under that isolated corner criteria in the code. I think it's important to note, Mr. Yates referred to tanker trucks earlier, and certainly that is one of the type of fueling vehicles, but I do want to just put on the record that, when you're talking about tanker trucks, it's not all semis. It doesn't have to be these large 18-wheeler tankers. There are other smaller fueling vehicles that can be used to refuel a site and gain access to a site as well. And then last but not least, I did just want to, mention that in addition to the operational considerations that Mr. Yates talked about with regard to why the access to Gordon Road is necessary, if we do look ahead and see a situation where we start disallowing access to commercial on local roads, we're going to put severe operational pressure on our intersections that could otherwise be avoided. It's actually the type of development we're trying not to do. We're trying to have better interconnectivity between our neighborhoods. And for example, if the property to the east of Gordon were to fall within the locational criteria, maybe be available as a lower intensity transitional use in the future, if we didn't have that access on Gordon Road, those trips are going to have to impact the collector roadway, which is something we're trying to avoid. So I would really strongly caution against removal of that Gordon Road access for both of those reasons. And I'm happy to answer any questions you have.
At this time, but thank you so much. I appreciate it.
Michelle, would you please mute your
Now
microphone?
we'll turn to the Planning Commission.
Juwan Haley, Planning Commission. The subject property is designated Residential Plan 2 on the future land use map. It is located within the limits of the Riverview and South Shore Area-Wide Systems Community Plan. The site is located within the rural area. Bear with me for 1 second. Okay. Planning Commission staff has expressed concern over the Gordon Road access and the compatibility concerns and preliminary comments in meetings with the applicant's agent. The application notes that the Gordon Road access is required and necessary per Hillsborough County Public Works and Transportation staff. While the request and site plan have moved closer to addressing staff's concerns, the eastern access onto Gordon Road, a local street serving single-family homes, still remains. This access presents a compatibility issue, as it will bring additional traffic from new commercial uses onto a local street. The access is inconsistent with policy 16.5 and the future land use element, which requires that higher intensity non-residential land uses adjacent to established neighborhoods be restricted to collectors and arterials and to locations external to established and developing neighborhoods. The subject site meets locational criteria as the site is located within 660 feet of the Big Bend Road and Balm Riverview Road, a qualifying intersection. However, per policy 22.7, commercial locational criteria is not the only factor to be considered for approval of non-residential uses. Considerations involving land use compatibility, adequacy and availability of public services, environmental impacts, adopted service levels of affected roadways, and other policies of the comprehensive plan and zoning regulations would carry more weight than the locational criteria in the approval of the potential neighborhood commercial use. The locational criteria only designate locations that could be considered, and they in no way guarantee the approval of a particular non-residential use. A single-family residential lot is located immediately north of the site. Single-family residential lots are also located to the east of the subject property across Gordon Road. The proposed gas station and car wash in close proximity to single-family residential presents compatibility concerns. These lots will be directly impacted by the gas station and car wash. Policy 16.2 requires that gradual transitions of intensities between different land uses be provided as new development is proposed and approved through the use of professional site planning, buffering, and screening techniques and control of specific land uses. Policy 16.3 specifically addresses compatibility and the integration of land uses through the creation of light uses and mitigation of adverse impacts. The proposed gas station and car wash will not integrate or provide a gradual transition into the neighboring single-family residential uses due to the intensity of the proposed commercial use. Introducing additional traffic along this roadway line by residential uses are not consistent with Objective 16 and Policy 16.1, 16.2, 16.3, and 16.5. Planning Commission staff has been informed that the applicant has agreed to a condition of approval that would restrict fueling trucks to the Balm, Riverview, and Big Bend Road accesses. It is the Planning Commission's understanding that fueling trucks will not be able to access Gordon Road. Other vehicles will still be able to access the site via Gordon Road. Policy 16.5 states that development of higher intensity non-residential land uses that are adjacent to established neighborhoods shall be restricted to collectors and arterials into locations external to established and developing neighborhoods. The policy does not provide exceptions to the restrictions regarding collectors and arterials. Consequently, the request still undermines the intent of policy 16.5. The community design component in the future land use element also contains policy direction about designing developments that relate to the predominant character of the surrounding area. It further states that new development should recognize the existing community and be designed in a way that is compatible with the established character of an area. Because the surrounding land use pattern to the north and east is mostly single-family residential, the proposed gas station and car wash would not be compatible with the existing development pattern located north and east of the subject property. The Gordon Road access is also not consistent with Goal 4 of the Riverview Community Plan, which calls for protection of low volume and uncongested neighborhood roadways. Based upon these considerations, Planning Commission staff finds the proposed plan development inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you. I'm available if you have any questions.
You, Ms. Haley, I have two questions. The first was the question I posed to Ms. Heinrich about the residential designation of this property on the Riverview Community Plan. If you could please talk to me about that.
I'm sorry, can you repeat that one more time? You want to know the uses permitted?
Yeah, the staff report indicates that this property is designated residential district on the Riverview Community Plan. The Riverview District Concepts Map is what it's identified as in the staff report.
Correct. So if you give me 1 second. So residential plan 2, it does call for agricultural, residential, and suburban scale neighborhood and community commercial office uses, multi-purpose and clustered mixed-use projects. And non-residential has to be consistent with commercial locational criteria. So that's RP2.
From is the Development Services staff report. It's the third paragraph, and it says the subject property is located within the Riverview Community Plan, specifically within and this is in quotations, the residential district, end quote, on the Riverview District Concepts Map. So my question was, what does that mean? What does the residential district on that concept map mean?
Okay. I'm going to get that language for you. If you could give me just 1 second, okay?
Absolutely.
So according to the community plan, the residential district vision, the residential district appeals to people of many economic and cultural backgrounds in this area. Managed growth permits higher densities. The improved infrastructure containing fiber optic communications, sidewalks, pedestrian-friendly crosswalks, adequate lining and signage is well maintained and controlled by strict code enforcement. So basically, the intent of the residential district division is for higher density development. So it's just a vision for residential development within this particular part of Riverview.
Thank you. And then my second question is if you could answer if your recommendation, if the Planning Commission's recommendation of denial is solely based on the full access to Gordon Avenue.
No, it's not solely based on that. As indicated in the staff report, it's also a compatibility issue. That's why we pointed out the various policies under Objective 16 concerning compatibility as well. And as you will see in the staff report, there is a significant amount of time discussing compatibility. This is an issue also of gradual transition of uses. Yes, gradual transition of uses can be addressed through mitigation, but sometimes it's just an issue of the nature of the use. So as stated in the report, we do recognize the applicant has spent a significant amount of time and they have worked with staff to try to address our concerns through mitigation such as elevations and buffering. But there is an issue with the very nature of the use itself transitioning directly into residential.
All right, thank you. That's the end of my questions. I appreciate your testimony. All right, now we'll call for anyone that would like to speak in support. Anyone in favor of this application? Seeing no one, anyone in opposition? Anyone opposed to this item? All right, no one. County staff, anything further?
Nothing
Ms.
further.
Finch?
All right, Ms. Corbett?
Yes, thank you, Kami Corbett. The PowerPoint.
Oh, okay.
Michelle, did you have something to add?
Yes, I was just going to answer Ms. Finch's previous question.
Apologize, I didn't know you were wanting.
No problem. Are you able to hear me, Ms. Finch?
Yes.
Okay, I did check our zoning atlas to get you some information regarding your previous question about the location of any other nearby commercial zoning districts. And in looking at that map, I see there is CG zoning that is approximately 0.7 miles south on Baum Riverview Road, and then also commercial zoning about 1 mile east, Big Bend in the Triple Creek Village Center.
Okay, all right. Thank you for that clarification. I appreciate it.
Thank you.
All right, Ms. Corbett.
Okay, and if I could go to the PowerPoint, Kami Corbett again for the record. I wanted to talk about policy 16.1 and 16.5. This is a neighborhood protection policies. And it talks about 3 ways to protect neighborhoods from encroachment of commercial. One is the locational criteria. So we would agree that's not the only criteria, but that is met. The other is limiting it to neighborhood scale. As you heard Michelle Heinrich testify, we're at 0.08 FAR when 0.25 is permitted. So we are significantly less intense than is allowed under the plan. And then lastly, through requiring buffer areas and screening devices between unlike land uses. And you heard testimony this evening that we are doing both of those things as well. Next slide. This again is a slide of policy 16.5. And I will tell you from having worked on the case, although the report cites to other issues of compatibility, the primary issue that forced the recommendation of denial was the Gordon Road access. And again, the Planning Commission is reading this policy to mean that no access can be permitted on a local road, and that's the intent of this policy. But I don't believe that's true. The intent is to have the higher development of the uses adjacent to established neighborhood to be restricted to collectors, and then to locations external to established and developing neighborhoods. Here you have the intersection of the collectors where we meet that. And then here you see how we're external to the surrounding neighborhood. We are not internal to this neighborhood at all. We are external. Additional conditions to protect the neighborhood is, again, limiting the FAR to 0.08. We did increase setbacks, increase screening, enhanced architectural design standards. You'll see that in the staff report and on the site plan. And then no truck traffic is permitted on Gordon Road. All of those things were done to address compatibility issues. And then lastly, most importantly, there's no objection from the neighborhood. We have no parties of record submitted any written objection. Development Services received no objections from neighbors. The location has access to a local street grid, as Mr. Ratliff pointed out, which relieves congestion on collector roads. And this creates opportunity for a neighborhood to have neighborhood commercial within walking distance of the subject property. This is an area of very active citizen participation and citizens groups, including the Baum Civic Association, even though we are not actually located in a Baum community plan. And we have received no objections. And we had, most importantly, we've received no objection from any of the single family residents in the surrounding area. So clearly they don't see that their neighborhood has to be protected from this use. And I think that probably speaks volume for whether or not this is incompatible or compatible. No, never mind. We agreed to this as a condition. So, and with that, unless, I think Michelle, we had the same findings that Michelle had as far as the commercial development in the surrounding area, and we agree with that. And with that, we would respectfully request your approval.
All right, thank you so much for your testimony. Then with that, we will close rezoning PD 20-0307 and go to the next case.
The next item is agenda item D2, rezoning application PD 20-0308. The request is rezone from AR, AS1, and RSC6 to plan development. Laura Marley will provide staff recommendation after presentation by the applicant. Oh, and I will note that for the record, we did put in the record a transportation report by Transportation Review, and they're available if you have any questions regarding that.
Thank you so much. Good evening.
Good evening, Madam Hearing Officer. Those are both the makeshift and the virtual dais. Michael Brooks, 606 Madison Street, here on behalf of the contract purchaser, which is BL Holdings. I have with me tonight our client, Daniel Bergen and Ben Larson, a representative of the seller, Lee Winter, neither of whom we're going to speak. Michael Razor was not able to be here tonight, but he's our traffic consultant and well represented in the backup. And Isabel Albert, who is our ASCP planner, is going to give the primary piece of the primary presentation here. The property is just generally at 30,000 feet, is 55 acres. It's in the CMU 12 land use category. It is adjacent to the Tampa Telecom Park, a project, Ms. Finchett, you're probably very familiar with. The northern boundary is Tampa Telecom Parkway across the entirety of the property, which is also the jurisdictional line for the city of Temple Terrace and will be a theme that we'll be talking about. So with that, I'm going to hand.
Mr. Brooks, can I just?
Yes, ma'am.
I want to just cut to the chase here real quick, because there seems to be in my reading of the backup, before we get any further.
Sure.
There seems to be a consensus that this, from both planning staffs, that this is a compatible use, that what your proposal is acceptable, with the exception of the timing mechanism of development, that there's a lack of that. And so therefore, the Planning Commission didn't support it, and therefore Development Services didn't support it. So could we just get to that before we move on any further as to why you haven't proposed that?
So, caught me out of order.
I apologize.
Yes, that is our understanding of both of the
You would
staff
agree
reports.
that's the crux of the matter.
That is the crux of the matter. And Ms. Albert was much more engaged in the Planning Commission discussions that led up to that. So I don't want to totally speak to this issue, but from the legal perspective, and I'm going to put into the record case law that we believe is relevant to the interpretation of 19.1. And the crux of my position is that there is no timing mechanism that is either required, set forth in the face of 19.1 that is logically inferred. In fact, what the staff report says is that in order to guarantee a mix of use, we need a timing mechanism, and we were requested to propose one. The timing, those are two completely separate issues. The zoning itself is what establishes the mix of uses. And as a practical matter, when we are challenged to even schedule hearings, to ask our client to commit to a timing mechanism for a parcel that we know is, which would be Pod B, is not going to be the first to be developed. It's just simply not reasonable in the middle of a pandemic, first and foremost. And if the Hillsborough County Board of County Commissioners, when it adopted the comp plan, had intended for there to be a timing mechanism similar to what you know, and we all know in the RP2 district, for example, where X percentage of commercial has to be completed before X percentage of residential certificates of occupancy, then it certainly could have said so. And so we simply don't believe that that it's a requirement. We think that the case law is very clear on how you interpret land use regulations. And frankly, it doesn't make a lot of sense to the ultimate goal.
Okay,
At least
well,
as
fair
it's
enough.
stated
I
by
just
the
wanted to
planning
make sure
commission.
that we were all on the same page as
Yes.
to how you want to proceed. So go
Yeah.
ahead.
Okay, I'm going to let Ms. Albert come up because as to the timing mechanism, the connectivity is a piece of it as well. And she can speak to that. Thank you.
Thank you. Good evening.
Good evening, Isabel Albert with Half Associates, 1000 North Ashley Drive, Suite 900. I am assisting with this rezoning application. So I'm glad that you got it quickly, that the whole point is this timing mechanism. I'll get through that as we talk through the presentation. So what we have, this is a site. It's located on Telecom Parkway, between Hello Stump Road, which is a private road, and the Tico easement to the east. So what we have is in the area, it's quite a unique situation because Telecom Parkway is in jurisdiction of the city of Temple Terrace. Everything north is in the city of Temple Terrace. Everything to the west is city of Temple Terrace, and to the east, a portion of it is city of Temple Terrace, except that vacant piece of land here. Over here. Oh, you can't really, okay. That vacant piece of land there. So what we have is the land use. So we have the future land use of CMU 12, which is located in Hillsborough County. Across the street, we have UMU 20, which is located in the city of Temple Terrace, and as well as the Research Corporate Park to the west. Now, interestingly enough, is the city of Temple Terrace mixed use category, which I've put down here. You see the CMU 12, that's for the city of Temple Terrace, even though it's not next to us, but the UMU 20 does not require a mix of uses. In fact, they look at what's around them and it's already a mix of uses without that requirement. What we have before you tonight is we have two parcels. Well, it's actually one large parcel. Pod A is for multifamily development as well as townhome development. And Pod B is for the commercial component of it. What we have in between is actually the city of Temple Terrace stormwater pond that they were given to them, the area, in order to do those improvements to parcels to the north as well as Telecom Parkway. Telecom Parkway was finished construction a couple of years ago where they connected from Fowler to Morris Bridge Road. Thank you. And so by that construction, we have that. We met with development services staff to explain the situation, and they understood of the unique situation and that this could be reviewed as a unified plan development, even though it is somewhat separated by an easement and a stormwater pond. Planning Commission reviewed it and named all these policies that we meet. There's a lot of policies starting with a minimum density. We are in the urban service area, so we have to meet the minimum density requirement of the comprehensive plan. The land use categories we had to meet this mixed use of land use categories is what we were providing. Policies 9.1 and 9.2, that's the relationship with the land development code. we feel that we do meet all requirements of the Land Development Code. Policy 13.3 has to do with the environmental sensitive land credit. Our site has more than 25% of wetland area, so therefore we apply the density credit that's in the policy 13.3, which we applied that, and even by applying that, we still meet the minimum density requirement. We have the neighborhood and community development, make sure that we're compatible with the area, with all our neighbors, which we are. And then you have these objectives that has to do with community design component, mix of housing types, and also to make sure the infill and mix of uses isn't found in this urban area, which we meet all of that. But most importantly, we are in the community mixed use land use category, and we have to follow the comprehensive plan that has objective 19 dealing with the mixed use requirement. We meet every single one of them. You look at it, we have a requirement of 2 land use within the CMU 12. We are providing that. We have to have at least 10% of the total building square footage. In this instance, Planning Commission interprets by using the number of units. And so it's like 320 units, so you have to have 32,000 square feet of commercial. We meet that. We provided land for that. Mixed use horizontally integrated is what we have. We have a uses, you have the commercial component, the residential component. And those mixed use can include commercial, office, residential support use is what we have. We don't know who the end user is, but we wanted to provide a mix of those uses that could cater to different end users. And whoever comes in, well, we would have that zoning in place for that. And policy 19.2, we do meet all of that. We meet every single thing, you know, the zoning district, the street connectivity as much as we can possibly, you know, knowing the fact that we do have a parcel that's separating A and B. And with that, the connection, the internal connection was very difficult to meet, but that's why we wanted to provide some kind of pedestrian cross access. But by providing this pedestrian cross access, you have to keep in mind that we're going over an easement that's used by City of Temple Terrace. And even though we have all the use permitted that we can do within that area, we still wanted to meet with the city to find out, hey, this is what we're required to do. Do you have concerns with us going over the easement? And so actually going back to that, so the applicant has met with the city and has done numerous meetings with the city officials, city manager, city attorneys, see how can we best make this work. And during those conversations, we received from the Planning Commission saying, I understand you have to do all that, but you need to have a timing mechanism to ensure, you know, that this mixed use is going to occur, because to ensure that the intent of the mixed use criteria of the comprehensive plan can be met with limited interconnectivity, which is what our situation is, Planning Commission staff wishes to see a phasing condition of development to ensure the second use will be developed in a timely manner. So we looked at that and says, well, it's kind of hard because our site is split, but if we have to meet some kind of interconnectivity, let's discuss this with the city. So Danny went, met with the city officials, and during that conversation, city said, okay, I don't object since you have a right to use this, but if you think about it, we have a multi-use trail that is existing on either side of our property with a missing link. If you could build that missing link, that would help not only your parcel from A to B, but it also helps the community as a whole. So we're like, okay, we are going to build this light green multi-use trail that connects to the darker green, and that meets and helps everybody in the neighborhood. So we felt like that met the interconnection as best as we could and meet the intent of the comprehensive plan. And then, unfortunately, development services staff also agreed that there was no compatibility issues. Planning Commission, there's no compatibility issues anywhere. But because of this lack of commitment, they couldn't support it. And for me, I've worked in this county for 20 years. I've done mixed use rezonings for most of that time. And we were told that, oh, this is what we require. We require this in numerous timing mechanism. And I really had to scratch my head. I had to talk to coworkers that have done plan developments. I've talked to different other planners and land use lawyers. I said, where am I missing this? Because I don't see it in the comprehensive plan. I pulled every single plan development that we've done within my company, that I've worked on or had knowledge of. Nowhere does it say in the Planning Commission staff report that a timing mechanism is needed. Nowhere are there conditions that's required that. They talk about the two uses, they talk about the mixed use, the two uses, the 10%, the interconnectivity, all of that, but nowhere. And I have these here for you. But, it's a great project. We meet the intent of the comprehensive plan. This is a mixed use. This is an infill. We're also helping out City of Temple Terrace with their mixed use trail. And we find it is consistent with the comprehensive plan and compatible with the surrounding neighborhood, which we don't disagree with development services staff or planning commission staff for that matter. Part of it is we have a design exception. Hollow Stump Road is a private road that's been serving the property to the west. And it's sort of like a two-section. The section in red is where we provide that sidewalk that will go and connect to the sidewalks on Telecom, and the rear portion to the south is to serve the residential single-family couple in there. We also did receive a letter of objection into the record by Mr. J, and call him by Greg and Jay. And so we've been working out with them. We've been working and communicating with them, and they have today provided a letter of support saying, okay, we have no more objections. You have met our requirements. If I can have just one more second, because I do want to talk about, thank you. We also, because we had no support from staff, we had to come up with our own conditions of approval. So what we've done is we've pulled the agency comments. There's no objections from any agency's comments. We have we applied those conditions that need to be normally into conditions. We also received just tonight conditions from transportation staff. They have no objections, and I concur with all their conditions except this one condition is condition number 5, where they talk about, and I don't know if you have that.
I do.
Okay. So, and I will give that,
I have it.
Okay. All right, so condition number 5, it has, a requirement of interconnection, and they say, the developer shall construct an internal pedestrian and vehicular connection between pod A and pod B. The vehicular connection, from our discussion with City of Temple Terrace, I don't think that it was a good idea to have a vehicular connection. I believe that it's going to change the nature of what this development is supposed to be. But not only that, if you look at, the existing, can't really tell, but actually, yeah, you could probably tell there. That square that's coming out, right next to it, that's the easement. It's not a pave easement. It's not a clear, it's like a dirt grass easement. And the county is saying, well, why don't you just go ahead and put a road across that? I don't think that it really meets or it doesn't achieve anything. We would like to provide, we can provide a pedestrian cross access, but our efforts are being focused on Telecom Parkway to finish that multi-use trail.
Can you show me on your site plan that illustrates pod A and B?
Yes.
Where they're requesting relative to the easement? Where is that?
So if you could see on there, you've got those little dots as we show as pedestrian connection between A and B.
Mm-hmm.
And this is about 30 feet wide, and transportation staff is recommending that we put in a driveway in there to connect to B. And we feel like it's not necessarily achieving anything. It's going to be, we're focusing more on Telecom Parkway with the multi-use trail to do that. And also, I have an email, and I will provide this, but an email from the City of Temple Terrace manager saying, you know, we definitely would prefer a pedestrian versus a vehicular.
So just so I'm clear, the connection between A and B is a multi-use trail
On Telecom Parkway.
on Telecom Parkway, right? And so otherwise, as you apply, there is no connection other than that between A and B?
We do propose a pedestrian just north of the pond, south of that square. So you see those little dots?
Yeah, it would be helpful if you could point to
Oh,
that.
there you go. It does work.
There you go. Yeah, absolutely.
Sorry, right here. Okay, there you go. So this is the pedestrian that we're proposing to meet that internal connection that's,
It's pedestrian only.
We're proposing pedestrian only,
Okay.
yes.
And then show me the multi-use trail.
Multi-use trail starts here and goes all along, oh, I'm trying to control this, Telecom Parkway, all across up to here.
All
to
right,
meet.
so then there is no vehicular connection between A and B, is what you're saying?
Correct.
Okay. And that's what the county is asking, the
They're
transportation
asking for that,
section?
yeah. We would rather not. And then in my discussion with Mr. Ratliff, he says, I'm going to put that in there. I'm not objecting. And I think we left it at that.
If you were to connect it, you would have to go through the City of Temple Terrace's property with vehicular connection?
It's an easement, so we own the property. No, actually, City of Temple Terrace owns it, but yes, we do have to go over that property.
Through their property?
Yes.
Okay, understood.
And that's why all these discussions started with the managers and the, the head of different departments to come up with an agreement to help us help them.
Okay, I understand. Thank you.
And so I will provide into the record the conditions that we're proposing, as well as transportation conditions, trying to make it, as clean as possible. So I'm here if you have any questions.
Nothing further at this time, but thank you.
Thank you.
Mr. Brooks, did you have anything before we move on? All right. Okay, thank you so much. Then we'll turn to Development Services.
Good evening, Laura Marley, Development Services. The subject property is approximately 55.20 acres. It's within the urban service area, and there are significant wetlands on the southern portion of the site. The site is surrounded on at least two sides by the City of Temple Terrace. The applicant is proposing to rezone the subject property from AR, ASC1, and RSC6 to planned development to develop 331 multifamily units, 320 multifamily units, and 11 townhomes in Pod A, and up to 33,000 square feet of BPO uses or CG uses or community residential home in Pod B. As discussed, staff does find the proposed zoning compatible with the surrounding area. There was several versions of the site plan that we did review, and we did get comments in from the City of Temple Terrace and FDOT relatively last minute, as it was required because the roadway of Telecom Parkway is a local road in Temple Terrace, and the applicant has worked with Temple Terrace and FDOT for the access management, but the application is found to be not supportable based on the inconsistency with the comprehensive plan because of the ensuring a timing mechanism. They just wanted some relation on when they were going to get built. It didn't have to be, a certain, they wanted a certain time of building the units compared to when it was going to get built, because like I said, it took a long time to get here. And Planning Commission did say this method has been used in multiple rezoning applications. There has been conditions. So staff is going along with the Planning Commission that we cannot support the application. And in reference to the connectivity, Mr. Radliff would like to address that. Thank you.
Thank you. Mr. Radliff.
Hello, yes, thank you. I did just want to point out that we did recommend approval, of course, in our staff report based on the connectivity condition, that essentially that pedestrian only link be made into a vehicular and pedestrian connection. And that's for a number of reasons. As you know, the County Commission is very concerned about connectivity and providing multiple links between uses. In fact, the actual definition of a planned development is that essentially, this is according to 50301 of the Land Development Code. It says that the intent of planned developments is to encourage creative, innovative, and/or mixed-use development. And so we don't think that segregating those uses into discrete pods, essentially, not mixing them, achieves that goal. And there's also Land Development Code section 60201A13, which addresses that issue, as well as within the comprehensive plan, the future land use element, the community design component within the future land use element, section 5.2, policy 13-1.4 states, talks about designing communities around a grid network of streets and to improve interconnections. And so with that, I did just want to put on the record that our support for this was conditional upon that being a shared vehicular and pedestrian connection there. We understand that the city of Temple Terrace may prefer for that not to happen, but of course we develop respectfully under our rules. And our understanding is that that is a non-exclusive easement, and so there's nothing that is prohibiting those rules from being followed in this case. With that, would happen to answer any questions.
Mr. Ratliff, just to be clear, your testimony is that your support is based on that connection between, that vehicular connection between pod A and B.
That's correct.
All right, then now we'll go to the Planning Commission.
Jawan Haley, Planning Commission. The subject property is designated Community Mixed Use 12 on the future land use map. It is not located within the limits of a community plan. The site is located within the urban service area. The proposed development is compatible with the area and meets the intent of future land use elements objective 1 and future land use element policies 1.2, 1.3, and 1.4 as it provides growth in the urban service area. The proposed multi-family housing and non-residential uses are also compatible with the development pattern in the area as required in policy 1.4, as the area is primarily residential in character, and there are multi-family housing developments directly to the south and north of the subject site. Similarly, the proposal meets the intent of Objective 16 and its associated policies regarding neighborhood protection and compatibility. Per Objective 16, Policy 16.1, 16.2, 16.3, 16.8, and 16.10. The maximum permitted density is 334 units, and the proposed 331 units is consistent with the density expected in the commercial mixed-use 12 future land use category. The proposed density also meets the minimum density required in this urban service area per future land use element policy 1.2. While the proposed development is compatible with the development pattern in the surrounding area and the applicant has demonstrated connectivity between pods A and B, Planning Commission staff must find the proposed rezoning inconsistent with the comprehensive plan because there is no timing mechanism in place that would guarantee a mix of uses. Providing a timing mechanism through a condition of approval is one of the only ways a mix of uses can be demonstrated. It is also the method that has been used in multiple previously approved rezoning applications. Future land use element Objective 19 outlines the intent of all mixed use categories in the comprehensive plan. Future land use policy 19.1 specifically states that requirements for 2 land uses will apply to properties 10 acres or greater in the RMU 35, UMU 20, and CMU 12 land use categories, and to properties 20 acres or greater in the SMU6 and MU4 land use categories. Furthermore, according to policy 19.1, at least 10% of the total square footage of the building must be designated for a second use. While the applicant has shown a second use on the site plan that meets the threshold outlined in policy 19.1, without a timing mechanism that would require the second use to be constructed at the same time as the multifamily residential use, the proposed plan development is inconsistent with the comprehensive plan. Objective 8 enables the future land use map, and policy 8.1 mandates the range of accessible land uses in each classification on the future land use map. Policy 8.2 requires all development to be compliant with the future land use element of the comprehensive plan, and the proposed rezoning does not meet the intent of community mixed use 12 future land use designation as required by the future land use element, since a timing mechanism is not in place for the project. Furthermore, objective 9 and 9.1 require all development to meet or exceed the land development regulations in Hillsborough County, and that development inconsistent with the comprehensive plan shall not be approved for rezoning. As the proposal is consistent with the CMU 12 category of the comprehensive plan, it does not meet the intent of objective 9 and policy 9.1 and 9.2. At the time that the staff report was written, the application still had unresolved transportation issues as well. Based on future land use policy 9.2 having been resolved, having been unresolved at that time, the plan development is inconsistent with the comprehensive plan. The community plan, the community design component in the future land use element also contains policy direction that encourages mixed use development in urban and suburban areas. The intent of the surrounding land use pattern is mixed use development, both in the areas that are in unincorporated Hillsborough County and Temple Terrace, especially across East Telecom Parkway, where the future land use is urban mixed use 20. A development that does not include a timing mechanism does not meet the mixed use criteria required by the community mixed use 12 classification and is therefore inconsistent with the comprehensive plan. Based on these considerations, the Planning Commission finds the proposed plan development inconsistent with the future of Hillsborough comprehensive plan for unincorporated Hillsborough County. Thank you.
Ms. Haley, I just want to make sure I understand your reading of the policy regarding the mixed use requirement. Is it your testimony that the timing mechanism, that the commitment you're asking from the applicant is to ensure that mix of two or more uses? Is that correct?
Correct.
And so could that be in the form of at the, for example, not to suggest anything, but for example, would that be after the 10th multifamily unit is developed, then a certain percentage of that non-residential use must be constructed? Is that how that works?
It can be something like that. It depends how, it's usually a condition of approval, and we usually work with the development services and crafting that condition, but that it could be something to what you suggested, correct?
Necessarily need to be a date and time issue, but it can be after so many units, then so much square footage of the non-residential use must be constructed. Is that correct?
Right. Usually, so in this case, it would just be a condition of approval. So when it went to site development, those who are reviewing it for development would know that these two things have to be built at the same time, and that would ultimately fulfill the vision of the plan. So it's usually language that's in place that would just make sure that, okay, yes, maybe residential or primary use is being built, but there will also be something in place to ensure that that 10%, that secondary use is also being built at the same time. And like I said, it can be crafted in various ways, but it's usually a condition of approval that ensures that.
And so just not to belabor it, but just you added a little different thought in that your description is while the residential use is being built, then a certain percentage of the non-residential development must be underway as well.
Correct.
Thank you for your testimony. I appreciate it. All right, we'll go back to proponents. Anyone who would like to speak in favor of this application? Anyone would like to give a testimony? All right, seeing no one. Anyone in opposition? Yes, sir, if you could please come forward. While he's coming forward, is there anyone else that would like to speak in opposition? All right. Come forward and just give us your name and address, please, to start.
Hello.
Good evening.
My name is Malcolm Sherritt, and I'm a resident on the Northern Rappahorn Drive. We don't have trash pickup. Our road is broken off into pieces. We can't get deliveries up there. Nobody wants to take responsibility. The supervisor for trash pickup texted me, could I walk my trash across the street for them to pick up because our road is broke off? Also, that area is a sanctuary for birds. There are gopher turtles out there that need to be removed. I know it's very expensive, $1,500 each, but these are my concerns. I've been there 40 years. It should be made into a park for a wildlife conservation, but I see no benefit as a landowner there on that northern road, Rappahorn Drive. We can't even get a garbage truck down there. This has been going on for almost a year. And I'm an old man. I can't haul garbage across the street to another corner. My trash pickup. It's really a problem. And I hope it gets resolved soon. I don't hear anything in talked about helping us on that northern Rappahorn Drive, which is part of this. I'm in the Hillsborough County section, that one little unique section. So that's my concern. That's all I have to say.
Thank you, sir. I appreciate it. If you could please sign in with the clerk's office. Here, right here, you could sign in. Thank you so much. All right, seeing no one else in opposition, we'll close that portion of the hearing and we'll go back to county staff. Mr. Grady, anything else?
Nothing further unless you have questions.
No, I don't have questions other than, no, that was my only question was the prior one to the planning commission. So thank you. All right, Mr. Brooks, you have 5 minutes for rebuttal.
Thank you, Madam Hearing Officer. As I've struggled with a way to characterize what we've been dealing with here, I'm torn between the death of common sense and no good deed goes unpunished. Part of the reason that the reason that there's a Pod A and a Pod B is because grandmother Ripple, who has since passed away, and this land is in her family, provided the drainage parcel that separates or trifurcates, however you want to describe it, right? What was the parent parcel. So that is what created the discrete pods. And I have to say that when we're talking about street grids and interconnectivity within the larger context of being adjacent to the Tampa Telecom Park and all of the activity that's going around there, I just have a hard time coming up with the rationale for why all of these strained relationships or interpretations. And I'm going to leave you with more cases than I know you care to read. But I challenge you to find a timing mechanism requirement in policy 19.1, 8.1, anything else that was suggested. The fact that the Planning Commission can't tell us what that timing mechanism is says all we need to know. I think it's also important for you to know that this site plan originally started out with just the apartment parcel, Pod A. And that Pod A was going to be developed or was being proposed under the waiver provisions, right? with the, under 19.1, if you were within proximity to, in this case, the Verizon Center was next door, an enormous employment center, and you have a continuous sidewalk on the same side of the road, then we wouldn't be here today, but for the fact that on the long-range transportation plan, Telecom Parkway has not yet been updated to reflect the fact that it is now functions as a collector because it has been connected to Old Morris Bridge Road. So I felt like we were in a Seinfeld episode over all of these rules back and forth. We started in one direction with a waiver that worked, but the map wasn't updated. So we put Pod B back into it, and I appreciate Mr. Grady's efforts and Mr. Moretta's efforts to help us do that. And now we're kind of stuck between this connectivity issue and this timing mechanism. Like we can't find a way out of the cul-de-sac, not to pardon the pun. The bottom line is that if you feel in your planning expertise that the connectivity is a requirement and is necessary, we will do what we have to do in that regard. I just don't believe that it's necessary. The trail provides really what the activity center is about. And I don't know. You've got substantial competent evidence. You've heard from Ms. Albert. I don't know which direction to go here, but I think everybody has agreed this is compatible. It's consistent. We're hung up on nuances here that just frankly don't make a lot of sense to me. I'm sorry.
All right, thank you for your testimony. I appreciate it. Then with that, we'll close rezoning PD 20-0308 and go to the next case.
The next item is agenda item D5, rezoning PD 20-0475. The applicants are Bay Bayou Florida RV Resort LLC. The request is a rezone from AS1 to NPD to a planned development. Laura Marley will provide staff recommendation after presentation by the applicant.
Good evening.
Good evening, Madam Zoning Hearing Officer. Oh, I see.
Thank you.
Good evening, Madam Zoning Hearing Officer. My name is Matt Newton of 101 East Kennedy Boulevard, Suite 2800. I was in the parking lot earlier, so I've not been sworn yet.
Okay. If there's anyone else here or virtually that has not been sworn in, if you could please stand and raise your right hand for this or any other case on tonight's agenda. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
This application is much more straightforward, so this will be very brief. We're up here in the western portion of the county, Oldsmar here, at the corner or just east of the intersection of Hillsborough Avenue and Old Memorial Boulevard. What this is we're seeking to. Oh boy, can I turn this? Clockwise. If I can shift this. My apologies.
No problem.
What we're doing is we're seeking to expand the real estate of an already approved PD to allow 8 additional recreational vehicle spots. And this aerial here is from the property appraiser site, and it just kind of demonstrates where we are. Here's this triangle here. Essentially, this was approved for 60 RV park spaces back in 2005. We haven't been able to build all of them in 2005. So we're adding a couple of acres from what is currently zoned AS1 to allow that to be built out quite a bit. This is the future land use map, very interesting section of the map. The triangle I just pointed to is right here. This is R6. Recreational vehicles spaces are a allowable use within R6. as the Planning Commission points out. Across the street, you have R4. Across the street, you have R4 here, and then light industrial here and OC20. The uses in the vicinity are very consistent with that future land use map. Across the street, we have some single-family residential. Here in the industrial section, we have a milling factory, and then right here, this is under construction. This is some multifamily. The canal here really creates a natural buffer in between these uses. So really, there's no compatibility issues, as staff points out in its report. A zoning map here, you can see this chunk of AS1 looks kind of like an artifact of what's been developed around it, largely planned developments back in the 90s and early 2000s. And then getting to the meat of it, here is PD05 I'm gesturing to. This was these original 60 units that were approved. Not a lot of detail on here. This is the new planned development. As you can see, just kind of going out a little bit into here, this is largely wetlands here. I'll show in the next slide that we have a variance to develop a little bit into it to get these sites on. I just want to clarify, we're not requesting any additional units than what's already been approved, just to be able to fit some more on a neighboring parcel. This was not and the property owners, they bought this in 2018. This was zoned in 2005. So that wasn't really an option when it was originally developed. In here, this is the already approved. This was approved back in 2007 while this was being developed. This is the wetland setback. This was approved by the land use hearing officer in August in anticipation of this rezoning to allow the parcel to be developed. It's largely unusable without this. And something that staff points out as well is we are asking for a waiver to build just this one recreational vehicle spot. Under the land development code, you need a 50-foot setback to put RV spaces along Old Memorial here. In 2005, there was a waiver approved to allow a 10-foot setback. We're actually asking for that to be extended just a little bit to allow this additional unit. And as you can see from this aerial, that will be consistent with the existing development. Staff is in support. We're pleased with the conditions. We're pleased with the staff report. It's very comprehensive. Happy to answer any questions you may have.
I just want to make sure, based on your testimony, so the planned development that's approved is approved for 60 RV spaces?
It is.
And how many are existing right now?
I was texting with the civil engineer. I tried to count somewhere between, I think, 40 and upper 30s. I'm really not sure. I was trying to count on there. I texted him, but I didn't get a text back.
Okay.
But well under the 60.
All right. And so the request is to add the additional acreage to get all 60 on there. Is that correct?
To allow up to the 60.
Up to 60. So no more than what was originally approved.
Exactly.
All right. That was my only question. Thank you so much. Development Services, please.
Good evening, Laura Marley, Development Services. Bayou RV Park is an existing RV park that has a maximum of 60 units. The applicant is proposing to add 3.25 acres of ASC1 to the PD to allow for additional area of the RV park and to allow 10-foot setback on Memorial Highway. The design per the applicant will only include one unit utilizing that reduced setback. The existing RV park PD 050111 had the approved setback with the approval and development in the new parcel will be consistent with the RV park that's existing. The RV units are not increasing. It's going to stay at 60 units at the maximum. And as the applicant said, they obtained a variance recently to allow a 20-foot setback when a 50-foot wetland preservation area setback is required. Planning Commission finds the request consistent, and staff finds the proposed rezoning compatible with the surrounding area and finds the application approvable subject to the changes from the transportation section prior to the site certification and the 17 conditions proposed by staff. Thank you.
Thank you so much. Planning Commission, please.
Jawan Haley, Planning Commission. The subject property is designated Residential 6 on the future land use map. It is located within the limits of the town and country in northwest Hillsborough. community plans. The site is located within the urban service area. The proposed rezoning to planned development for 60 RV spaces is comparable to the existing residential development pattern in the surrounding area, consistent with future land use element policy 1.4. Compatibility per future land use element policy 1.4. Compatibility does not mean the same as, but rather includes uses that are similar to the surrounding uses. The proposed plan development includes 60 RV spaces, which is consistent with the residential 6 future land use category. The site contains more than 25% wetlands, and therefore the environmentally sensitive land credit per policy 13.3 is applicable to the site density. The site is 11.87 acres, which includes 3.85 acres of wetlands and 8.02 acres of uplands. The maximum density that can be considered for the site is 60 dwelling units. The proposed 60 dwelling units is consistent with the density expected in residential 6 and is therefore consistent with the comprehensive plan. The proposed development is also consistent with policy direction in the Northwest Hillsborough Community Plan by providing another housing option suitable for a range of ages and socioeconomic backgrounds. Based on these considerations, Planning Commission staff finds the proposed rezoning consistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County, subject to the conditions proposed by Development Services Department. Thank you.
Much. Is there anyone that would like to speak in support of this application? Anyone in support? All right, seeing none. Anyone in opposition? Seeing no one. County staff, anything else? Mr. Grady?
Nothing further.
All right. Sir, did you have anything else you'd like to say?
No, thank you. Thank you for your
All right,
consideration.
thank you. With that, we'll close rezoning PD 20-0475 and go with the next case.
The next item is agenda item D6, rezoning PD 20-0877. The applicant Shadow Woods Lots LLC. The request is rezoned from RSC 6 to a planned development. Israel Monsanto will provide staff recommendations after presentation by the applicant.
Good evening.
Good evening. William Malloy, 325 South Boulevard, Tampa, Florida. This is an application for a planned development. It involves about 14.7 acres of vacant, undeveloped land just north of Jackson Road in the greater Carrollwood area. The request is to allow for up to 48 detached single-family units, again, on about 15 acres. The current zoning is RSC 6 with a future land use of R4. And on that unit count, our overall density would be about 3.27 units per acre. This planned development would function as really an extension of the PD just to the south. Same neighborhood, same developer, same builder. Access to the project will be provided through, again, the existing PD. Access to Carrollwood Cove is a subdivision to the east. We're asking that be limited to emergency access only. And I'll explain about that in just a moment. Minimum lot size here would be 6,000 square feet. With a minimum width of 50. That's again the same standards as to the south. The project is in the urban service area, so county water and sewer. To that point, it's a very straightforward application with no waivers or variances requested. We do not have development services support on this one. And the reason is So here's Jackson Road. This is our primary means of ingress and egress. This is the existing development. It's actually a slightly dated picture. The expansion would be up here, this area. This is the stub out that Carrollwood Cove, the adjacent subdivision, has. The LDC says we need to connect there, a full connection. We are asking for emergency access only based on the fact this is a private gated community. So our gate is approximately right here. The only thing that cross access would provide, other than very much riling up these neighbors.
Mr. Malloy, could you speak into the microphone?
Oh, yeah, pardon me. The only thing that cross access would provide, other than very much riling up these neighbors, is a second driveway onto Jackson, just about 250 feet away from our existing driveway. This neighborhood only has one way in and out, and we don't see that as a functional or useful connection.
Okay.
So that's the only wrinkle on this case that I'm aware of. I'd like to reserve my time for rebuttal. I believe we have some opposition tonight. I'd also like to introduce Mr. Dave Ford and Mr. Steve Henry real quick, just for the record, in case they need to speak down the road.
Okay. I appreciate it. So we'll go to Development Services.
Okay. Very good.
Thank you.
Israel Monsanto Development Services. I will share my screen. One sec. As the applicant stated, he seeks to rezone two parcels, 14.7 acres in total size, currently zoned residential single-family conventional RZ-6 to a planned development. This is the two parcels being rezoned per this application. The request is to allow up to 48 single-family conventional detached dwelling units. The site is generally located between Timberland Street and Jackson Landing Place in Tampa. The site is within the greater Carlwood-Northdale community plan, and it is in the urban service area. The proposed density is 3.27 dwelling units per the acre, below the maximum allowed by the area's comprehensive plan future land use of residential 4. The site is surrounded by residential uses to the east and the south, multifamily to the west, some other single family to the northwest, and a county park to the north. Minimum lot sizes proposed will be 6,000 square feet with a minimum lot width of 50 feet. The applicant is requesting one full access connection to Jackson Landing Place.
So I'm not sure. The only thing we're seeing on the screen is a copy of this like staff report. So I'm not sure if you're showing the right graphic, because I assume you're wanting to show some graphics, because all we're seeing is
It's an aerial
the
map.
staff report. Is that what you're intending to show?
Oh, give me 1 second.
It looks like a document.
Okay, I will do it again. 1 second. Okay, it is down here. Yeah, it should be another document. Do you see an aerial?
No, it is still a Microsoft Word document.
All right, well, let me then stop sharing then, I guess. Okay, I will continue with my presentation without the graphic for now. So the applicant is requesting one full access connection to Jackson Landing Place to the south, connecting to PD 180402, privately maintained roadway, which ultimately connects to Jackson Road. The applicant is also proposing an emergency access, as stated earlier, connecting to Carlwood Cove Drive to the east and pedestrian connection to Timberland Street to the northwest. As indicated in the transportation staff report, although the applicant is proposing an emergency access connection to Carlwood Cove Drive to the east, the connection is required to be a full connection and be consistent with Land Development Code Section 60201. Staff noted that the applicant did not provide justifications within the narrative as to why the full access could not be made or any supported comprehensive plan objectives or Land Development Code regulations. Adjacent zoning districts permit residential uses today. Zoning districts located in the vicinity are currently developed with lots comparable to the development standards being proposed for the subject PD. Areas neighborhoods have a medium residential density. Although the proposed project will be compatible with the area's prevalent single-family residential development pattern, in order for the project to be in full compliance with the Land Development Code regulations, as stated before, a full access connection is being required to the east instead of an emergency access only. Transportation staff has indicated that the full connection will be needed to comply with code requirements, and therefore is not supporting this request. Planning Commission also cites inconsistencies with plan objectives, and due to the project not meeting code requirements for access, they also are recommending not supportable. Therefore, based on site access issues indicated by the transportation staff, Development Services does not support this request. No objections were received from other reviewing agencies, and Development Services and Transportation staff are available if you have any questions. Thank you.
Mr. Ratliff, if I could talk to you about the access issue.
Yes, ma'am.
Just explain the request for the full access.
So essentially, the Land Development Code contains provisions that talk about, well, there are varying supporting conditions within 60201A13. But I think the most direct one is that it essentially says that this is 60201A16, that all streets, alleys, and pedestrian pathways in any subdivision shall connect to other streets and to existing and projected streets outside of the proposed subdivision or other development. So essentially the development to the east was constructed with this as a roadway stub out for future connection. And that connection was required not only to comply with the Land Development Code connectivity provisions, presumably, but also to serve as emergency access to serve that project, since all of the lots within that development to the east is not within 1,000 feet of their access. So it also requires emergency access. So it provides, that dual functionality there. And so again, because the Land Development Code requires continuation of the existing street system, we had to recommend denial of the project.
The proposed emergency access doesn't meet the intent of that requirement?
No, again, the requirement is also to provide multiple direct connections between and to different places. So again, in this case, I think that there is a little bit maybe more nuance that could potentially be looked at. Staff doesn't really have that latitude in terms of we do understand what the developer is saying, that essentially in this case, the road just goes back down and loops back into itself to the south. So it doesn't really provide any additional connectivity. All roads in that case lead down to Jackson. I think certainly bicycle and pedestrian connection is critical, right? We don't want kids who are maybe, have friends in the other neighborhood to have to, walk down on busier Jackson Road just to go visit a friend's house. But unfortunately, again, the way the Land Development Code is written is why we had to be providing.
So much. Planning Commission.
Juwan Haley, Planning Commission. The subject property is designated residential 4 in the future land use map. It is located within the limits of the Greater Carrollwood Northdale Community Plan. The site is located within the urban service area. The proposed single-family detached residential would allow development comparable to the development pattern in the surrounding area. The subject property is surrounded predominantly by single-family residential lots. The request is consistent with the intent of the residential 4 future land use category, which allows residential development. The subject property is located in the urban service area where 80% or more of new growth is directed per the comprehensive plan, objective 1 in the future land use element. The proposed development is consistent with goal 2 of the Greater Carrollwood Northdale Community Plan, which seeks to reinforce community identity through maintenance and enhancement of the community's unique characteristics, assets, and physical appearance. New development and redevelopment are required to use compatibility design techniques to ensure the appearance, mass scale of development is integrated with the existing suburban nature of each neighborhood. The proposed development is comparable and compatible to the surrounding predominantly residential development pattern and is consistent with the vision of the community plan. The application states that an emergency vehicular connection will be provided to the east. A full access will be provided to the south. The proposed use would promote infill development and provide development that is comparable with the surrounding area. However, in order for the project to be in full compliance with the Land Development Code, regulations, a full access connection is required to the east instead of an emergency access only as proposed by the applicant. Transportation staff has indicated that the full connection will be needed to comply with LDC section 6.02.01. Policy 9.2 states that developments must meet or exceed the requirements of all land development regulations as established and adopted by Hillsborough County, the state of Florida, and the federal government unless such requirements have been previously waived by those governmental bodies. An emergency-only access to the east also undermines the intent of Policy 16.3, which requires pedestrian and vehicular connections. It also undermines Policy 16.7, which requires connections to residential neighborhoods. Consequently, the request is inconsistent with the comprehensive plan. Based on these considerations, Planning Commission staff finds the proposed plan development inconsistent with the future of Hillsborough Comprehensive Plan for unincorporated Hillsborough County. Thank you.
Thank you very much. We'll ask for anyone that would like to speak in support. Anyone in favor of the application? Seeing no one. Anyone in opposition to this request? Yes. All right, if you could, everybody come forward and line up if you could. And start by giving us your name and address. Now, we have 15 minutes total. How many people would like to speak?
My name is Faith
If you could,
Filipello,
excuse me, ma'am, just hold for 1 second. How many people would like to speak? 3? I see 3 people. Sir, are you going to speak? 3,
We're
4.
dividing it up 7 and 7.
Excuse me?
We were dividing it 7 minutes and 7 minutes for them. We're 2 different communities.
Oh, okay. If you got this worked out, but we are going to hold it at 15 minutes. So if you could pull this microphone down to you and give us your name and address, please. If you could give
Can you hear me
7
now?
minutes. I can. Thank you. Please
All
proceed.
right. My name is Faye Filipello, and I live at 11719 Carrollwood Cove Drive, Tampa. Thank you all for letting us come before you and voice our concerns about the opening of a full access exit onto our community. We are speaking on behalf of 31 families who were promised an emergency-only exit by Mobley's lawyer at the last HOA meeting. Now we're informed that is inconsistent due to the county's rules. We have many families who have young children who play outside, ride bikes, and play basketball in the street. They have pets that they love and walk them daily. If open to a full access, the peace and safety of our small community would be destroyed. This exit would not benefit Mobley homeowners since their community and ours both exit onto Jackson Road. When Mobley subdivision is finished, it would bring some 200 cars, 2 cars per home, and our 60 cars. During rush hour, this would create a traffic nightmare. All this traffic would come to a halt at the intersection of Jackson and Casey. Right now, it's hard getting onto Casey Road unless someone lets you in during the rush hour. To make matters worse, the school bus stops at that very intersection. Jackson Road has no sidewalks, not enough street lights needed during the dark winter months so children can walk to school safely. Many of these problems can be solved by either making an exit to the north from Equestrian Horse Farm and connect to Timberland Street. I've driven down Equestrian Trail into the horse farm, and it can be done. Or grant us the emergency-only access and have it in writing, not to be opened in the future. There is also another, to have the county extend Jackson Road through the Beacon Meadows Park with chain link on one side to protect the park and chain link on the wetlands to protect the wetlands. Why destroy our little community when there's alternatives? Lastly, it would be we have a living pond that we created with the Adopt a Pond program. This would be devastating to our pond. So please, when making your final decision, vote in favor of the common good and how it will affect the lives of these families and their children. Thank you.
Thank you, ma'am. If you could please sign in up here with the clerk's office. Next, please. Good evening.
Good evening, guys. My name is Peter Toth.
You can bring that up to you.
Oh,
There you go.
appreciate that. I forgot I'm tall. I'm a special case for this one. I couldn't decide whether I was in opposition or in opposition. So I'm going to say that I'm actually in favor of what the lawyer said earlier about having the gate as an emergency access only. It was already stated that both communities will empty out into Jackson Road, which doesn't solve the traffic problem. It just creates traffic for us and our kids. The problem with Jackson is just it's a one-way street for all the communities. So a solution would be to open up a street that's adjacent to the community there. I have a picture here on, can I show this at all?
You cannot, because
Okay.
you can't submit it into
I
the
can't- I
record.
can't
You
show
can
this.
describe anything you
Okay.
like.
So a new road could be built adjacent to the playground there, or I don't know, making it Jackson Road safer by adding sidewalks. Something could be done there, but leaving it emergency access, I'm in favor of that. What I'm not in favor of is making it a full access. Making it a full access for everybody will make more traffic for us, make it dangerous for us. 100 homes, that's 100, 200 cars. It's gonna be a lot of cars coming down our road. I mean, and it just empties into Jackson, like I said. So hopefully you can approve that it's emergency access only. So
Thank you so much. If you could please sign in with the clerk's office.
Yep, thanks.
Next, please. Good evening.
Good evening. My name is Mary Best. I live at 5003 Timberland Street. I apologize now, I've never done this before.
That's okay.
So, and to what they've been speaking as far as Timberland, the development will be right next to Timberland Park, who on a regular basis has Pee Wee football, Pee Wee cheerleading. We're a very old developed neighborhood. We don't even have a 2-lane road. It's a single lane road. My father-in-law has been there since 1962. It's just not a developed community to be able to handle this type of traffic, along with the north side of the property where Equestrian Inc. is all wetlands. So you would have to come through wetlands to be able to exit onto Timberland, which, and that turn, you have to go all the way down to Four Oaks before you can even get to Gun Highway to get to a traffic light. We also have no public utilities, no sidewalks. We have children that walk 3 to 4 blocks to get to their school bus. We also have, on a regular basis in our neighborhood, there's gopher turtles, there's protected animals in there. It's just not a feasible exit to come through Timberland. Alone, you cannot even get 2 vehicles to be able to pass each other on that road. It's a 1-lane road. It's a very old, developed neighborhood. So that's my opposition, is coming out the north end and off of Timberland.
Thank you for your testimony. If you could
Thank
please
you.
sign in with the clerk's office. Next, please. Yes, sir. Good evening.
My name is Peter Filipello. I'm a resident of 11719 Carrollwood Cove. And I'd like to bring y'all up to date as to what we were promised to our community. We were promised a emergency gated exit off their property onto our Carrollwood Cove Drive. Their lawyer said that it would not be a full access. It would be a private, only for emergency only. And that was their promise to us, which we will accept. Our neighborhood would accept a emergency exit. Come to find out, according to the PD, the county says they are not in favor or will not agree to the emergency. They want a full access. Well, I went to our community to see how they felt about it, and they were all opposed to a full access gate. I made a petition to present to the board, and the petition reads, as a resident and homeowner of Carrollwood Cove Association residing at 11719 Carrollwood Cove Drive, I strongly oppose the opening of an exit to the east onto Carrollwood Cove Drive by the Mobley Building Company. This would greatly increase the amount of traffic through our neighborhood and would only become a detriment to our small community. Also, for exiting purposes, it would not be of any real value to either party. The solution of a second exit can be remedied by an exit to the north onto Timberland. This would provide them with the second exit they require and alleviate the traffic problem and not impact our small community. We would like to thank you in advance for your cooperation into the matter. I would like to put this into record, submit this into record. Also, along with my petition, I have 30 more petitions to submit to the board. And they were all from our community. They all signed it. We have petitions from everyone, 30 of them. We have 38 homes on our community, and we got 31 petitions.
All right, thank you, sir. If you could submit them into the clerk's office and then also sign it. You could, to the clerk, yes, and I'll see them from there. Thank you. Anyone else that would like to speak in opposition? Yes, ma'am. Give us your name and address, please.
Good evening.
Bring the microphone to you. Perfect.
My name is Joanna Caveda, and I am a resident at 11721 Carrollwood Cove. I just wanted to make sure that, because at first we didn't want that full access, but if we did come to an agreement, and I do apologize, this is my first time, but if we were to come into an agreement for emergency access, is there a way that if it was to be like turned over to full access, can we fight for that? Because if we're going to come into an agreement for emergency access and then turn around and it's a whole different story, is, just looking for that.
The application is proposed to be emergency access. That's what the applicant has proposed, and the county is not supporting that provision. So it will be up to the Board of County Commissioners ultimately to decide that issue.
Okay.
So thank you very much. If you could please sign in with the clerk's office. All right, anyone else that would like to speak in opposition? All right, seeing no one. County staff, anything further?
Nothing further.
All right. Mr. Malloy. Good evening.
Good evening. Steve Henry, Links and Associates, 5023 West Laurel, Tampa 33607. Got an aerial, want to put it up here to kind of better show you what we're talking about. So the first thing is the number of access points. Per the Land Development Code, this development with the phase 1 and phase 2 is only required to have one access point. So we've got our one access point, which is through Jackson Land. That's all we're required to have. The code talks about the cross access. In this case, it really makes no sense from a transportation standpoint. The cross access we're talking about is right here. This road comes down here, goes right down to Jackson Road. So it serves no purpose. Certainly an emergency access, we understand, and that makes sense from an emergency standpoint. But from a transportation standpoint, it makes no sense. There's no reason to have that cross access from a transportation standpoint because it's parallel roads. They go to the same spot. Jackson Road is a dead end road. It ends just to the west of our project. So it serves no purpose other than to, as these people said, put more traffic through the neighborhood, which from that standpoint, they all come down to here and we meet the code for the number of access points. And from a overall circulation standpoint, the additional cross access is not needed.
So the code, just to make sure I understand, the code requires, your testimony is the code requires one access point, one.
Well, yeah. For this particular project, it's based on the number of trips and the type of road that you're accessing. So for the number of lots that we've got and the type of road we're accessing, we'd only be required to have one access.
All right, then why even propose the emergency access?
Well, now it does require that for more than 10 lots, you have an emergency access.
Okay.
So we are required to have the emergency access, which we are providing.
Okay.
And we're willing to agree to that. And I think the neighbors are willing to agree to it being an emergency access. But it's not requiring the second access. Now, and again, if this road went over to Casey, provided additional cross access to other roadways, then it might make more transportation sense. But in this case, where it is simply going right back down to Jackson Road, 250 feet away from where our point is, it's not serving any transportation purpose.
Okay, I understand.
Before he's done, just so he can respond to this, I just want to
Yes.
clarify something for the record, because I know there's discussions, because the citizens that were objecting to the full access were suggesting using Timber Lane. The proposal is only pedestrian access to Timber Lane. That's what's the proposal, and also just from the constraint standpoint, it's really not possible to make a full vernacular connection to Timber Lane just because of available lands and wetland issues and stuff. So, but again, our proposal, the recommendation is just for pedestrian access to Timber Lane, not vehicular. I just want to put on the record and give him an opportunity if he wants to respond to that.
No,
He may not
absolutely,
need to.
that's correct. If you look here, this is Timber Lane here. There is not sufficient land or right-of-way to be able for us to connect to that roadway.
Mr.
So we
Henry,
have no
if you could-
opportunity to do that.
Excuse me, if you could bring your graphic down just a little bit. I can't see the northern part of your property. There you go. So show me the Timberland, the pedestrian access. Where is that?
So the Timber Lane is right here.
I see. All right, so that's
See
only
that
proposed as
there's not
pedestrian.
sufficient room in there to provide a right-of-way for a roadway connection.
So the only other opportunity is this emergency access point. I see. That's the only opportunity for a second access.
Correct.
Okay.
Yes.
All right, I understand. Thank you so much.
Thank you.
William Malloy again. Just to recap a few things on this, I am always very hesitant to go against development services, obviously with a recommendation. And if it was just the issue of a public neighborhood and private neighborhood, or it was just the issue that both driveways would wind up on Jackson Road at the same place, or it was just that the neighborhood vehemently did not want this connection, I don't think any one of those stands on its own, but all three put together, I think make a compelling case to keep that access point as emergency only. It's a position I did represent to the HOA in person, and we're going to maintain it going forward. So thank you.
All right, thank you for that.
And
So-
before we close it, just to
Yes.
note for the record, within the county's transportation report, there is, in the event, just to put it on the record, in the event there's a decision made regarding to not have that as a full access point, there's a proposed condition in there to address that. That to be the preferred condition from transportation in the event the board decides to not require the full access, but I want to just put that in the record for future discussion.
And that's in these.
In the
his-
transportation's report, yes.
Perfect. Okay, thank you for that clarification. I appreciate it. Then we'll close rezoning PD 20-0877 and go to the next case.
And the final item on tonight's agenda then is agenda item D7. It's rezoning PD 20-0969. The applicant's Rodine Development LLC. The request is rezoned from PD, AR, and AS1 to a planned development. Michelle Heinrich will provide staff recommendation after presentation by the applicant.
Good evening again. William Malloy, 325 South Boulevard, Tampa, Florida. This request is technically a rezoning, but for practical purposes, what we're doing is adding acreage to an existing approved PD.
Mr. Malloy, if I could just hold for just 1 second. If you could please clear the room, we need to continue. Thank you so much. I really appreciate you coming down. Have a good night. Go ahead, please.
So again, the vast majority of this PD was approved last year. We're bringing in 3 parcels, which were internal to the PD, weren't a part of it before. They total just about 4 acres. The additional acreage yields 4 more lots in the RP2 part of the project for a total of 334. And then as part of the request today, we're going to max out the entitlements for the R4 portion of the project, which is another 100 lots. As part of the conditions of RP2, that will increase our open space from 71 to 72 acres and increase the size of the village node to 4,509 square feet. Also, regarding the village node, we're making a request that daycare be considered as a use that counts towards the retail requirement in RP2. This is an issue that we've brought to the board before in the form of a PRS, so it hasn't been here presented by me. The board did approve it previously. We're also asking for
Mr.
another.
Malloy, can I interrupt you? I apologize.
Of course.
That was my question in reading the staff report on that particular issue. Was the PRS to the already approved PD?
This was a different PD.
A different PD?
Yeah, it was. Same geographic area, obviously RP2, same concept. You have your village center, which is supposed to contain a retail use. Retail falls under the category of residential support, technically, in the LDC. We thought it to be an excellent use in the middle of a developed subdivision, and the board agreed.
And so what, for the already approved PD 190310, how was that satisfied, that requirement, if there was one?
So the way the requirement reads, the retail is developed at a certain threshold of the issuance or platting of residential permits. So at this point in time, the retail element has not been realized because the residential component hasn't triggered the requirement for it.
Right, but was there a requirement, there was a retail or commercial use
Yes,
as a part of that already approved PD?
Yes, slightly less than what we're required to have today.
And that was not daycare, is what you're saying?
Correct. It would have fallen under, I believe it's just generic CN uses.
Understood.
Which daycare doesn't fall under.
Okay, please proceed. Thank you.
We're asking that the proposed daycare, if that all comes together, have a slight deviation from the 2-to-1 setback for height. It might be slightly taller than 25 feet. And then we're also asking that, as I just explained, the tie-in between the development of the commercial and the single-family lots now be tied to building permitting, not platting. So it would be an actual count, not a geographic threshold that's laid out on a map. Then with the inclusion of the new acreage, we've made some minor tweaks to the internal roadway network, some of the internal buffering. This project does include a school site, which we're going to maintain on the plan as it is. I think with that, we've asked for a waiver as to the location of the school, which should technically be by the commercial node. It's not. It's actually, I believe, in the northeast corner of the project. And we've asked for a reduction in the buffer criteria for the school. There are 3 previously approved design exceptions for the project. Steve Henry can speak to those. There's one additional one with this new iteration. Transportation staff has reviewed and re-reviewed all of that, and all the exceptions were found approvable. So again, those are the changes to the previously approved PD. We worked quite hard on these conditions to get here. Support everything that, or appreciate everything that Development Services has done. And other than the Planning Commission's objection to the daycare, I think this is a good, clean case. I'm happy to answer any questions.
No, you answered my question. Thank you so much. I appreciate it. Development Services.
Hi, good evening. This is Michelle Heinrich, Development Services. As you heard, this is a rezoning of approximately 192 acres from AR, AS1, and PD to a new PD to allow for a total of 434 single-family units, a commercial node, and potentially a public school. The site is located in both the RP2 and Res 4 future land use categories and within both the urban and rural service areas. The majority of the site, which is a little over 188 acres, is zoned PD 19310, which was approved for 376 single-family units and a commercial node. This PD, like the proposed PD, is also within 2 future land use categories and service areas, and it permitted 330 single-family lots in the RP2 area and 46 single-family lots in the Res 4 area. Under this PD, a little over 2 acres of AR zone property is being added into the RP2 area, and 1.89 acres of AS1 zoning is being added into the Res 4 area. So overall, this will result in an increase of 58 lots, and that would be 4 additional in the RP2. That would raise the number from 330 to 334. And 54 units within the Res 4 area, that would increase it from 46 to 100. That is due both to the increase in acreage and the applicants wanting to maximize the permitted density of 4 units per acre. Previously, the applicants did limit that to under 4 units per acre at 46 lots. So under this application with the additional acreage, they're trying to maximize that to the 4 units per acre. In area zone RP2, a density of 2 units per acre is permissible if it is done in a planned village format, which I'm sure you're familiar with. The primary characteristics of the planned village, number 1 is the preservation of open space and also achieving a clustering ratio of 3.5. The applicants are meeting both of those requirements. Also, a village note is required, which, as you heard Mr. Malloy state, was previously required. It is still required in this application. It still is required and does meet the location, which is to be within 90 feet of residential. And it has also been increased slightly because it is calibrated with the number of units that are proposed. As Mr. Malloy stated, in addition to the retail uses that are permitted in the village node, the applicants are requesting that daycare also be an allowed use. Development Services does not object to this request based upon a similar request made in another planned village, 190529, wherein the Board of County Commissioners found the use to meet the same intent as a commercial or retail use, while also providing needed service for families within the project. Also, the project does comply with providing a maximum number of the homes getting a view of open space, and also a compatibility buffer of 250 feet is to be provided around 70% of the site. For that requirement, as in the original rezoning, the applicants are requesting the same buffer reductions that they asked for in the first application. Due to time, I won't go into those specifics unless you certainly would like me to after hearing from others in the presentation. But essentially, it does provide a reduced buffer along the west and along the southwest areas. The other areas, which are adjacent to the RP2 areas, they're not proposing a buffer in those areas. Also, there's still a waiver to the location of the school. In the planned village requirements, the school is to be centrally located next to or within the village node. In this case, the school did ask that this be provided along Rodine so it could have immediate road access should the school be developed prior to the development. So Development Services did not have any objections to that request, as they did not in 19310. To wrap up, we did not receive any objections from reviewing agencies, and we do find it approvable subject to proposed conditions, and I'm available if you have any questions.
Just had one question, and that was about the personal appearance on another property that was used as the basis for supporting daycare qualifying towards this. Can you give me a little more detail about how that came to be in the discussion?
Sure. That application is the South Fork Planned Development that is also a planned village. Just like this case, they did have the required village node, which provides for a variety of retail and commercial uses. The applicants under a PRS application asked to include daycare as one of those. The discussion that occurred before the Board of County Commissioners ultimately led to them approving that request. And some of the remarks they made that they used in their findings was that they felt this served the same intent as a retail use. While not actually selling an actual good, they felt it still provided a needed service to families and even employment to the area, and therefore served the same intent. So therefore, they were interested in widening and broadening the types of uses that could be allowed in a village node to make it a successful project.
Thank you so much for that testimony. I appreciate it. Planning Commission, please.
Jawan Haley, Planning Commission. The subject property is designated Residential Plan 2 and Residential 4 on the future land use map. It is located within the limits of the Riverview and South Shore Area-Wide Systems Community Plan. The site is located within both the rural area and the urban service area. The purpose of the RP2 land use category is to promote self-sustainable development. The ability to obtain the maximum intensities and/or densities permitted in the RP2 land use category on parcels 160 acres or greater shall be dependent on the extent to which developments are planned to achieve on-site clustering, meet the intent of the planned village concept, and demonstrate consistency with policies 33.5 and 33.10. The requested design standards for smaller lots within the planned village is consistent with the RP2 future land use category. which requires clustering in order to prevent urban sprawl, provide for the efficient provision of infrastructure, preservation of open space, and the protection of the environment, meeting the intent of future land use element policy 33.6. The proposed use is meeting the minimum clustering requirement of 3.5 units per net acre. The applicant has requested a waiver to the 250-foot buffer requirement in certain locations. The applicant has provided justification to the waiver request. The request will not negatively impact any of the surrounding areas, any of the surrounding uses. Staff concurs with the buffer waiver and proposed conditions provided by the Development Services Department regarding the requested waiver. The proposed single-family detached development complements the surrounding area. The proposal satisfies the intent of the future land use element policy 16.3. The application also satisfies the intent of goal 12, objective 12-1, and policy 12-1.4 of the community design element, the community design component in the future land use element. The proposed plan development has been reviewed by the school board, meeting the intent of policy 1.33. Achieving road connectivity is an important component of planned villages. The site plan demonstrates roadway connectivity in multiple locations, meeting the intent of policy 33.11. The site is located within the limits of the Riverview Community Plan, which encourages attractive residential development that complements the surrounding character and promotes housing diversity. Plan Development 1911-72 is located east of the proposed site, which is approved for a minimum lot size of 4,400 square feet. The proposed use supports residential development that complements the surrounding character as well as provides for housing diversity consistent with the Riverview Community Plan. The applicant has requested the allowance of a daycare use to be counted toward the retail requirements as contemplated by Residential Plan 2, future land use. As per the future land use element definitions, a daycare use is considered a residential support use, not retail. Planning Commission staff acknowledges that the Hillsborough Board of County Commissioners previously approved a daycare use through PRS 19-0529 and deemed it to meet the requirements of future land use policy 33.10. However, adopted policy language within the comprehensive plan does not include residential support uses to be utilized in lieu of on-site retail. For this reason, Planning Commission staff is unable to find the request consistent with the comprehensive plan. Based on these considerations, Planning Commission staff, I'm sorry?
Go on.
Based on these considerations, Planning Commission staff finds the proposed plan development inconsistent with the future of Hillsborough comprehensive plan for unincorporated Hillsborough County. Thank you.
Very much. I appreciate it. Is there anyone here that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition? All right, no one? County staff, anything further?
Nothing further.
Okay, Mr. Malloy.
I just want to, William Malloy again, add that there is another RP2 PD that was approved for a Montessori school in the commercial node. I don't have the case number, but I do know it to be true. And then, in point of fact, last week, the board approved a RP2 PD, which completely waived the retail element of the planned village.
All right.
So we're not asking for any of that. We just, the daycare use seems to fit nicely.
Understood.
And that's all I have.
All right, thank you for that. I appreciate it. With that, we'll close rezoning 20-0969. What happened with the first case with where the applicant was not present?
The applicant never showed up for the first case, so I think at this point we would just need to continue this to the November 16th ZHM. So again, that'll be item C1, rezoning standard 20-0144. We'll continue that to the November 16th, 2018 zoning hearing, 2020 zoning hearing, master hearing, and we'll try to get in touch with the applicant to find out why they weren't able to make it.
All right, fair enough.
All right.
Then with that,
wait, there's someone here.
Oh. Are you here for the first case?
No, I'm just a member of the community and I've been observing. My name is Dana Cannon. I would like to keep my address confidential to myself. I live in Lutz I just had a few questions. This is my first time attending something like this. I saw signage in the area in which I live, going out on a money run today. So I wanted to know, how are future development plans funded?
Can I ask you how this hearing, I understand you've not been at this before. What we do is we bring up an individual case and then we take testimony relative to that particular case. So we have just completed the hearing for all of the cases, and that's when I call for testimony in support or opposition. That's the opportunity to ask questions about particular cases. It's not an open forum to talk about policy issues or anything like that. There is an opportunity for that with the Board of County Commissioners hearings. They have a public comment section where you can come up and ask them any questions you'd like.
Right. So for this question, I would have had to come up with each case and ask how their projects would have been funded?
Yes, yes. If you have a question about a particular case, that is an appropriate thing when we are discussing that case. And then when the case is closed, we move to the next case, yes. But they're pertinent to each individual application we have on tonight's agenda.
And certainly if you have some broader policy questions like that, we can get your contact information. We can certainly follow up with you and provide some more detail. Since it sounds like you have a question that sort of broadly applies to all cases and not specific to one, we can certainly provide that information also.
Correct.
Yeah, there is certainly county staff here that can take your name and contact information and try to help you get to the point where you can get your questions answered. Absolutely.
Okay, thank you.
All right. I apologize. You sat here and didn't understand that.
No, I did. I just didn't know if I should come up for each one. I didn't want to have to.
Understood.
But now in the future, I know, so I can be at the November 9th hearing because
16th, November 16th.
November 16th.
Yes, absolutely. And so you heard me go through the case and you heard me call for people who want to speak in support or people who want to speak. That would be the opportunity to come up and talk about the particular case. But if you have broader reaching questions, then you may want to talk to county staff and try to get where you need to be based on what your question is.
Well, I am speaking in particular to everything that took place today.
Okay.
So
you're more than welcome to come back to the November 16th. It's at 6 p.m. And participate in the hearing just like that.
But by then you guys will put things, what you will put.
There will be new cases on that hearing, not what we've heard today.
Correct.
Yeah.
Correct.
Absolutely. Okay.
No, not okay. Because my question still isn't answered. Is there an overview of, you can tell me how are they funded?
Again, that's, if we can get your content, we can talk to you after the hearing. That's not something, again, the hearing's closed and it's really, again, how projects are funded. I mean, that's a broad question that, we can certainly talk to you and get some answers for you. I mean, if you're, I don't know if you're talking about transportation infrastructure, utilities infrastructure.
Talking about it all. So the transportation for the community, that's for Temple Terrace, the future development plans that want to take place in Riverview by Big Bend. Those two are big,
Yes, and again, those are obviously involve other staff with our transportation and infrastructure that could probably best answer that. And again, we can certainly get that information to you and respond to those questions. Because again, they do sound like broader questions. They're not just specific to one particular zoning case, but they apply to everything and how development occurs within the county.
Correct.
Yes.
Okay, so how can I get that information?
When we close the hearing, I'll get your contact information. We can reach out to you and have some follow-up discussions with you and with appropriate staff. And
Okay,
again, if you feel after getting the information that you still feel that you want to speak to each specific zoning to raise those similar issues, then you can certainly come back to the November 16th hearing and raise those issues for those cases that will be scheduled for November 16th.
Okay, and so what was the deadline for November 9th? Was that more like a rebuttal of what's going on here today?
That's if you if you disagreed with the recommendations I'm going to file, then you have to file that by November 9th to speak to the Board of County Commissioners on that matter, on whatever your issue is.
Okay, and when does your decision making come through?
I file, what is the date I file? I apologize.
November 9th.
It's okay.
November 9th?
That's when you file your recommendation.
So, right, I have a deadline to file recommendations 15 business days following tonight's hearing, which is November 9th.
So you filed November 9th, and I have from the 9th to the 15th.
If you've not put any evidence into the record, you basically,
But one of your criteria was being here and being
if you
a part.
if you had spoken to the individual cases, again, that's the issue. Since we'd closed all the cases, you didn't speak. And again, we can speak to that after this hearing because again, that's probably appropriate discussion we can have after we close, after this hearing. So, but again, procedurally, you would have to speak to each individual case in order to qualify because again, we've closed all the hearings and so, they've been closed and so that opportunity unfortunately has been lost. And so, but we can explain that. And again, obviously, if you have the same issues and want to discuss on the 16th in November, we can do that.
Okay, and there's another one in the Tampa Palms community that I see that it says November 10th. Is that another public hearing that is similar to this?
November 10th is the Board of County Commissioners public hearing. And so you can certainly attend and speak at that public hearing on November 10th. That's separate hearings on November 10th.
And will they be able to answer more funding questions and how is funding and where these programs?
Well, again, I think let me talk to you when we're finished with this hearing and I'll get your more detailed information and see how we can respond to that. And then again, depending on your questions, what kind of detail you can provide on November 10th, I can't tell you, but certainly get you to the right people to have those questions answered for you.
Okay.
All right.
So I'll get that information from you or?
Yeah, we need to close this hearing and then Mr. Grady can get with you to get your contact information and try to get you the information that you want.
I can't provide that, but I can get the staff. Once I know exactly what you want, we can get the right staff to get in touch with you and speak to you.
Or may I have your contact information?
Sure.
Because I don't have an active number.
Sure.
So.
If you want to contact us, I'll give you my contact information. You can follow up.
Great.
Okay.
All right, thank you.
All right, thanks for coming down. I appreciate it. All right, then with that, we will close the hearing, the zoning hearing master hearing this evening. Thank you all for your time and testimony.